Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1031 et al. State of Texas et al. Petitioners versus Environmental Protection Agency and Michael S. Regan, Administrator, United States Environmental Protection Agency, and case number 22-1080 et al. Natural Resources Defense Council Petitioner versus National Highway Traffic Safety Administration et al.
Good morning, Council. Mr. Wall, please proceed when you are ready.
Chief Judge Srinivasan, and may it please the court. This case is West Virginia all over again. EPA is using an old provision in a new way to set standards so stringent that manufacturers are effectively forced to electrify their fleets. Now, to be sure, EPA hasn't required full electrification in one fell swoop, although it has made clear that day is coming. But West Virginia was just the opening salvo too. The point is that the power the EPA asserts here is hugely significant. It is the power to do away with the internal combustion engine, which would affect millions of jobs, restructure entire industries, and affect our relationships with hostile powers. Questions don't get any more major. EPA has nothing close to clear congressional authorization. The Clean Air Act doesn't even authorize EPA to set standards based on fleet-wide averaging. At the very least, the statute doesn't authorize EPA to set standards that can be satisfied only by averaging a whole bunch of zeros for electric vehicles. And even if EPA's maneuver were somehow authorized by the statute, it would still violate the APA because the agency improperly calculated EV emissions and erred in assessing the costs and benefits of the rule. I welcome the court's question.
How are they using the power in a new way? I mean, the bottom line, or where they're going, seems quite dramatic, but one difference with West Virginia is in West Virginia, they sort of redesigned how the scheme was operating, whereas here, the credits and the trading and the averaging are long established, as was inclusion of electric vehicles in the class. And then there's just a question of stringency, and they're turning the knob up from a 4 to an 8. And that's very costly, but it's not a difference, it's not a sharp difference in kind.
So I think the situations are parallel, and it is a difference in kind. I think the knob goes from 0 to 8. Because before it was a compliance flexibility. And what I mean by that was the EPA set a standard and manufacturers could meet it in different ways. They could meet it by enhancing the technologies on internal combustion engines, or they had the option if they wanted to manufacture more electric vehicles and meet the standard that way. What the agency's done here for the first time, Judge Katsas, is set the standard so high that even they don't dispute the only way to meet it is to do, in effect, what the factories had to do in West Virginia. You've either got to switch your power source, or and manufacture more electric vehicles, or you got to buy credits from Tesla.
Why do you say they don't dispute that? I thought that is a source of dispute. I mean, it seems like this framing question is pretty important, whether what they've done now is a difference in kind or a difference in degree, because your major questions argument is predicated on an assumption that it's a difference in kind, understandably. And if I'm understanding it correctly, the nub of your argument that it's a difference in kind is that for the first time, EPA is setting a target that's only achievable by use of the alternate technology. But where do they join issue with you in that characterization?
So at pages 55 and 56 of the brief, Chief Judge Srinivasan, they say, look, we don't mandate the technology that the automakers have to employ. And that's true in a sort of misleading sense. If you look at the rule says, pages 5 and 52, they're driving electrification. What I mean by that, the best place to look is if you look at page 908 of the Joint Appendix, there are two charts, two tables, 4-27 and 4-28. One shows what they believe the market penetration rate for EVs will be absent the standards, and that's 7% by the last model year. And the other chart shows what they believe manufacturers will have to do in order to comply with their new standards.
No, but there's a difference between what they have to do and what they will do. And that's what I'm wondering is, it's one thing to say that the only way to comply with the standard is by use of EVs. It's another thing to say that, well, you could comply in other ways too, but manufacturers are going to choose to do it by use of EVs.
So Chief Judge Srinivasan,
Can I just ask, let me just ask, do you think that that's not a distinction? Or do you think that that is a distinction and where they are is acknowledging that the only way to comply is by use of EVs?
I think that can't be a distinction that matters.
Okay.
Because I can't believe that West Virginia would have come out differently if the EPA had promulgated a rule that everybody acknowledged forced the factories to switch from coal and natural gas to renewables, and that was the only way to comply. But then they said, well, on its face, it doesn't actually make you do that, even though we acknowledge that you have to do it in order to comply. It would still have been a major question, and they still would have lacked statutory authority. So I don't think the distinction can matter to either of the relevant legal questions.
So counsel, what about the example of Subaru? Because the record indicates that Subaru has no electrical vehicles, but can comply with these standards through 2025. So that seems to indicate that you don't have to go to electrification in order to comply with these standards.
I can't speak to Subaru in particular because it hasn't joined the litigation. What I can tell you is we have made it a point in the throughout the briefing to say that manufacturers generally will have to make more EVs to comply. And as I say at page 908 of the JA and in the rule itself at pages 5 and 52, their words are, this drives electrification 2.5 times what the market rate would otherwise be. So even if there may be some manufacturer that can comply, just like maybe one energy company in West Virginia could have complied, I don't think they're disputing that the major questions doctrine is applied on an industry-wide basis. And here, the industry as a whole will have to transition to electric vehicles in order to satisfy these standards. And that will be even more true down the road because they've already announced that they want the penetration rate to be 67% by the early 2030s. And obviously, there's a parallel case this court will hear tomorrow where California has said it's going to 100%. So it's not like we have to sort of speculate about where this road leads.
So the premise of your argument, though, is that this rule forces electrification. That is the major question that you posit. But isn't Subaru evidence of the fact that this standard does no such thing? It just sets an emission standard, and there's flexibility in how you comply with it, and there's evidence that you can comply with it without electrification.
So, Judge Pan, it's the same answer I gave earlier. I can't go automaker by automaker and tell you exactly how each one will have to comply.
I'm not saying you need to do that. I'm just saying, isn't this evidence that that your premise is faulty?
I don't think, and we'll see this morning, but I don't think that the government disputes. I don't take the rule to dispute that automakers generally, not sure about Subaru in particular, automakers generally will have to manufacture electric vehicles at 2.5 times the rate that the market would otherwise support. Absent the rule, you'd have 7% of the overall fleet, and their rule says we're driving that to 17%. So that's a 10% increase. Just like in the Clean Power Plan case, it was an 11% increase. I mean, it is the exact same thing.
So suppose the reason that you keep saying have to, and I think what you mean is choose to, but there's no difference between choose to and have to. Right? I think is that a fair characterization at least?
I think that's fair.
Okay. So suppose the reason that manufacturers choose to now, whereas they wouldn't have before, is because battery costs have gone way down for EVs. Then, for your purposes, that still doesn't matter.
It still doesn't matter because it's like saying that if some of the industry had chosen to voluntarily comply in West Virginia, that the major question would have been different, or the statutory question would have been different. The question isn't how much power the agency has exercised in a particular instance, or exactly how much pain that imposes on regulated parties. For purposes of the doctrine, the question is, what is the scope of the power that the agency is asserting? And the power they assert is to force a transition from one kind of vehicle to another, from 0 to 100. And I don't think the government can disclaim this morning. That's the scope of the power. If they're right here, they could drive a transition fully from internal combustion vehicles to electric vehicles. And our point is just like the cap and trade system in West Virginia, it's not like Congress has missed this. It's looked at EVs repeatedly. It's said, we'll study them. It's rejected mandates. It's cleaned up liquid fuel. And in 2021 in the Infrastructure Act, right before the EPA's administrative fiat, it ordered a new round of fact-finding by multiple agencies. It said, we want more facts in front of us before we make a decision. And so from all of that, we think it's clear that Congress hasn't given the power to the agency to affect this kind of a transition.
Can I just, I don't want to derail, because I know we're going to have lots of questions on this axis, but I just want to at least address the questions of whether we should even be looking at this. And so there's two things in particular that I'll just tee up for you. One is timeliness, because of the cases that we have that you're well aware of,
Right.
to the effect that if there's something that the rule is doing that is just repeating what a rule in the same area has done before, then that's something that needed to have been raised at the time that the initial rule was promulgated. You're aware of that? And that applies both to the electrification piece and to the averaging piece. And then the other thing I'd like to get to is preservation, and whether, and especially on major questions. Why isn't it the case that nobody said anything about major questions? And we can have a debate about exactly when that term became a term that really became part of the lexicon enough that somebody should have used the term, but the concept wasn't new. And that was never raised before the agency to give the agency a chance to address it in the rulemaking process. So you maybe take them in that order, and timeliness and then preservation.
So I thought you might have some threshold questions, and I have 3 quick points on timeliness, 2 on preservation, and hopefully we'll get to them all at some point. On timeliness, what I would say is, this court said if it's the same approach, but here they didn't just use averaging. They used averaging to force electrification, which is a new thing. Even if you disagreed with me on that, my second point is, I don't think that anybody could challenge it earlier, because NHTSA has the power to fleet-wide average. Now, it doesn't have the power to fold in EVs, but it can fleet-wide average. And these rulemakings had always been done in tandem. And this court said in 2011 in the Chamber of Commerce case, if you have 2 sets of standards and they independently require the same thing, you can't challenge the one if you're not challenging the other. And we couldn't have challenged NHTSA's ability to fleet-wide average. And even if you disagree with me on both of those things, Chief Judge Srinivasan, I'd say the court's been clear about the constructive reopening doctrine. If you really change the stakes of judicial review, you constructively reopen. That makes a ton of sense. Agencies can do things all the time in small ways that don't hurt people and don't give them any incentive to sue. And then they can use the same power in a really major way that does change the stakes. And obviously then parties should be able to come in and sue.
But that, where have we construed constructive reopening in that way? Because what we just had a decision pretty recently in this peer case that talks about the scope of the constructive reopening doctrine in pretty narrow terms. I mean, it has to be fit within some pretty narrow parameters.
So I sort of think Peer is not a very good case, because in Peer, the sort of regulations have been promulgated decades ago and then never touched. And so I don't think there was really a very good or serious argument for reopening. The Kennecott Copper case that we've got in our reply at page 9, I think is one where the court said, look, if you really alter the stakes of judicial review, and again, that makes a lot of sense. We don't want agencies to rush in and challenge every time an agency does some little thing wrong if they don't really have skin in the game. But if you really change the stakes of what you're doing, then you should be able to come in and sue. And that's what happened here. Yes, they've been averaging for a long time, but that was a sort of deregulatory or industry favorable shield to allow a compliance flexibility. And then they took that shield and they turned it into a sword to make everybody convert from one kind of vehicle to another by putting a lot of zeros into the equation for EVs. And that seems to me to fundamentally change the stakes of judicial review. On preservation, Your Honor, these arguments have been around since Thomas in the mid-1980s. So it seems a little rich for me to the agency to come in and say, like, hey, we didn't have any idea that our statutory authority was at play. But I still think we did enough in the comments to say, you don't have the statutory authority for a trading program or a subsidy program. But again, if you
Is that
did,
all you need to say? I mean, yes, there's lines in there that talk about statutory authority, but is it really as simple as, the whole point of it is you're supposed to put the agency on notice of the particular thing that's being raised so that they have an opportunity to address it. I mean, it's sort of like having a line at the beginning that says, we think this is generally unlawful. There you're on notice of all the ways in which it's unlawful. It doesn't really help the agency very much.
I would take that point and concede it in other contexts here, where the ability to do averaging has been on the table for decades, but nobody has since challenged it because it was favorable to the industry. It seems to me the agency's been on notice for a long time that its authority was at play. But again, I don't need the court
Why?
to...
I don't understand that. What's the point? That no one, there, at no point in the rulemaking process did somebody specifically say, hey, here's the issue we have with your rule.
So I think they did say you lack statutory authority, I think to your earlier question, they didn't come in and say major questions. Now, was the major questions doctrine fully formed at the time? But I take the point that the idea and the concept were sort of out there in the law. I don't think that you have to put agencies on notice of the law. You don't have to come in and say, hey, Chevron's the standard of review or clear error for facts. The major questions doctrine is the law, that the governing law that this court applies. I do think we needed to put them on notice of our objection to their statutory authority under that governing law. I think we did that, but I don't need the court to agree with me on that because the court's been clear that quite independent of the exhaustion requirement, which deals with whether we are entitled to raise and have something heard on judicial review, the agencies have a burden to come forward and put forward a non-arbitrary rule. And to do that, they've got to be willing to examine the fundamental assumptions that underlie the rule. And the court said multiple times, your statutory authority is one of those. And I don't see any reasonable argument on the other side that they're going to be able to get out of what this court has called the key assumption doctrine. I mean, the whole point of the rule is we're going to force electrification by making you fold in more electric vehicles. And I don't see how the agency can come to this court and say, we didn't consider that, we didn't have a burden to consider it, and nobody raised it during the rulemaking, so you, court, can consider it. It seems to me this court has correctly said, no, independent of what comments somebody makes in front of the agency has to examine its fundamental assumptions when it puts forward a rule for it to be non-arbitrary, and we, court, always have the authority to review that, independent of whether a party has a right to insist that we do it.
Problem with that argument is it seemed to suggest that no statutory authority or no statutory argument is ever subject to an exhaustion requirement, which really can't be right.
So I wouldn't go that far, Judge Katsas. I think there are lots of statutory.
There's no statutory authority. It's an essential element of their burden to, it's an essential element of their burden to explain their authority to do what they're doing.
I think for the core stuff, yes. I see daylight between those two things. I think there may be statutory questions that come up in a rulemaking that don't go to the core of the rule and that the court might be prepared to say are not foundational in a way that triggers the key assumption doctrine. This just wouldn't be the case because the whole core of the rule is, can we take our averaging approach, which granted, they've used since the 80s, but can we take that now and not set the standard so that you could comply with your improving the way that you burn fuel in an internal combustion engine? Can we mandate a transfer to electric vehicles? And that's the core of what this rule does. And so whatever you think that the key assumption doctrine covers, I think it has to cover this.
Does it mean then the premise of the key assumption doctrine is that the agency kind of is always on notice that it has to discuss these things because that's just general background stuff that the agency should always wrestle with. If it's always going to be the case that somebody can make an argument that a difference in degree, that something that one side might characterize as a difference in degree is actually a difference in kind, such that major questions applies, does that mean that every time an agency promulgates anything, they got to deal with the possibility of a major questions argument?
So again, I don't think so, but for a closely related answer to the one I gave to Judge Katsas, which is, we've all seen a bunch of rulemakings, and there are lots of statutory questions that come up, and I just don't think it would be persuasive to say that all of them are foundational to what the rule does or that all of them trigger a major question. But I do think that here you have what is a fairly unique case where the agency didn't examine the core of what the rule does in the face of some Supreme Court cases that to me sure seem to say this is a major question. If it is a major question in the vaccine mandate case or the student loan case to take an accepted power and use it in a new way, I've got to think it's a major question to take an invented power and use it in a new way. Whatever they think about averaging, they can't say the statute addresses it. The best the government can bring themselves to say is it's silent, and hence we read that as a delegation to be able to do this program. And whatever that is, it's not clear congressional authorization. That doesn't mean you need to touch averaging, but I do think it means that the court should say major question, can't force electrification in the way that you're doing with the averaging, full stop, and that takes care of the case.
You're also making an argument that even aside from major questions, that there's no authority to average and there's no authority to take account of EVs.
That's right, but the easiest way to resolve the case, Chief Judge Srinivasan, is not to go straight to the statutory arguments de novo, but to say It's a major question as the
Right.
Supreme Court's
No,
understood it.
I understand the reason you've sequenced it in the way that you have in your presentation, both this
Right.
morning and in the papers. But in terms of preservation and timeliness and those things, you also have these other arguments that stand alone.
That's right.
Right.
We think it's a major question, and that makes it easy. You can just say no folding in the EVs, and that takes care of this case. But yes, if you disagree with us on that, we are saying straight up, the statute does not allow averaging, and it does not allow you to fold electric vehicles into the class, because the class in 202A is the class of vehicles and engines that emit the relevant pollutant.
Now, as to those arguments, if you just strip away major questions for now, just indulge me for a second with the assumption. So we strip away major questions for now, and we're just dealing with the core statutory arguments. As to those, what about timeliness and preservation?
So it's the same answer I gave earlier, which is I think that they took a fundamentally different approach here, which both changes the timeliness rule and constructively reopens. And I don't know that we could have challenged the use of averaging at all, as I say, because they'd always done it side by side with NHTSA. So I don't think it changes the answer on timeliness at all. And I'd say the same thing on preservation. We raise the statutory authority arguments, but if you disagree with us, it's still a fundamental assumption. Even if you don't think it's a major question, just straight up on the statute, it's still the core of the rule. It's still a fundamental assumption that they're able to do this under whatever you think the right statutory interpretation rule is. They've done something. They've commanded the industry that what used to be an option is now a
So
mandate.
every single time, it doesn't, we could do this for the next 25 cycles. And they keep doing the same thing every single time. And then on the 25th cycle, which is in 2164, they've still got to do the same thing.
Well, Your Honor, from here on out, I'm pretty sure that the comment records will reflect every single one of the things we're talking about today. But I sort of take the point. But again, I think that this is a fairly rare case. It's not like the key assumptions doctrine gets triggered every day. The court doesn't apply it all that often. But it's sort of said, look, if you didn't examine your statutory authority to do the core of the thing you did, yes, that's something that we as a court have the power to consider, notwithstanding the exhaustion requirement. That seems to me entirely right. And so the question is 202A clear that when you have a class of vehicles that you want to set a standard for, that only some vehicles in the class need to emit the relevant pollutant? And as long as that's true, you can dump other stuff into the class that doesn't. I don't think it's close to clear, and I don't even think it's the most natural reading of the provision. When I refer to a class and I define it by a characteristic, I'm saying that you have to have the characteristic to be in the class. If I say the class of drugs that produces drowsiness in the FDA's judgment, and then I told you that class includes drugs that are stimulants, you'd think I was nuts.
So let me ask you this. It seems to me the EPA has been tasked with setting these standards, and they've done so 4 times since 2010 using the same framework that they applied in this case. And really, your complaint is with the level that they set. And what would you have them do? They are required to set some level. Are you saying that they need to, when they set their level, try to hold back and set a lower level if it's going to encourage electrification? Because what are they supposed to do in executing their mandate to set these standards?
So, Judge Pan, I want to fight the premise just a little bit, right? I don't think we're just coming in and complaining about stringency. If they had done what they had always done before and set the standard in a way that it could have been complied with without electrification, just enhanced gasoline technologies, we could have come in and made a complaint like yours. I think it would have been less powerful. But like, look, we might be able to clean up fuel in this way, but it'd be really
they
hard.
don't have a requirement to set it in a way that avoids electric vehicles, unlike maybe NHTSA does. But EPA doesn't have that. They can consider electrification.
But that's the oddity, Judge Pan, that's why I think the major questions doctrine here has so much force. They don't have clear congressional authorization to mandate the transition. And the oddity of what
I'm sorry, but you are wedded to this premise that the core function of the statute is to encourage electrification. My question is, they have to set a standard, and they're supposed to set a standard that protects public health. And there's no requirement that they not consider electrification as one of the factors in setting their standard. So what are they supposed to do? Are you saying that they need to decide what the ultimate standard is and then scale it back to avoid encouraging electrification?
No, I'm saying they've always set the standard in a way that you didn't have to transition power sources. You could satisfy it
In a
by
way, you're saying
enhancing.
stringency.
Well, it's a difference in kind, right? It's just like in the Clean Power Plan case. It's just like asking, wait a minute,
Well,
how
in the
does,
Clean Power Plan case, they had to do a completely different thing. They had to go to different sources. This agency is doing what it has always done before. It's just setting a level, a more stringent level that you say forces electrification. And I don't think that's clear at all, based on the fact that we have at least one automaker in the record who can comply with these standards without electrification. And there's no mandate that they not consider electrification when they set this standard.
so all respect, Judge Pan, that's exactly the argument the government made in West Virginia. It said, we're just setting a best system of emission reduction for stationary sources and factories. And yes, maybe they're going to have to transition from one to the other, but that's traditionally what we've done. And we're just cleaning up factories, and we found a way to make them even cleaner.
But there's no mandate here that you must go to electrification. They're just setting a standard and saying, meet these standards however you can. It can be electrification, it can be not electrification, as Subaru demonstrates.
Sure, just like in the cap and trade case in West Virginia, you can meet it in lots of different ways. You can change your power system, you can buy credits, it's up to you. You can do whatever you want. And the court said, no, no, no. That's not,
So is there a difference between, we want the switch and maybe the switch is going to come about? So in West Virginia, the premise was that the switch was something that the agency wanted. Here, I still don't see where the agency is saying they want the switch. At least, I mean, I know that there were some things that were said by elected officials, but in terms of the rule itself, if you can point me to something great, please do. But there seems to me to be potentially a difference between we're trying to bring about this shift, and here's how we're trying to bring about the shift. Or, yeah, you might choose to do it this way because battery costs have gone way down. I get that, but we're not going to ignore that reality. That's just the reality of the world. And so this is the new percentage figures that are going to result. But you don't have to do that. You could do it some other way. We think it's totally within your bailiwick to do it another way. You might well choose to do it this way, but we're agnostic as to that.
just like in West Virginia, there is no other practical way to comply, Your Honor. They said in the rule, and they're right, that they're driving electrification. I don't think, I mean, we'll see what the government says this morning, but they didn't say in their
Where
brief.
did they say that? I saw the word driven. Did they actually?
It's in the rule. I believe it's at page 5, and then they recognize it again at pages 51 and 52.
Give me, is that, I'm very curious about the best statements in the rule. And if those are the ones, then I'll take a close look.
So look, I really think the best evidence is at page 908 of the JA, because there they give you the actual numbers. And
Those are the tables, right?
Those are the tables.
Yeah, yeah.
And they say market rate's going to be at 7 by the end. We're pushing it to 17.
But that's different from wanting that to come about. And that absolutely shows, I don't think anybody disputes, and EPA is not going to dispute, that there's a difference between 7% and 17%. And those tables bear that out, as I understand it, right? I've looked at those tables, and that's what they do, is they show that actually the incidence of EVs is going to go up as a consequence of the rule. But in terms of the agency wanting to bring about that change by the rule, as opposed to saying that's what's going to happen based on a number of factors, is there, you may think that doesn't matter, but for someone who might think that it does matter, or it could matter.
I guess the reason I find the question a little confusing, Your Honor, is because the first table on 908 and what they're talking about, and the top of the right-hand column on page 5 of the JA, is what the market rate would be absent the standard.
Yeah.
So that's what manufacturers and consumers would do absent the standard. And then they say with the standard, we're going to drive that number up to 17%. We're going to achieve an additional 10%. That would not happen absent the standard, forcing us to make more EVs in order to be able to comply with the more stringent standard. So I understand that as a have to, not a want to. If it were a want to, the 7% would be higher. That's what auto manufacturers would otherwise want to do absent the standards. So I don't see them sort of based, I mean, they can debate whether it's 7% or 8% or whether it's 2.5 times or all the rest. But it is notable that the government does not, in the voluminous briefing in this case, say anywhere, no, you can comply with this just by enhancing your technologies on internal combustion engines. I don't think it can be done.
You can't.
So it's not just the shift from 7 to 17, right? That might happen just from a change of incentives. It's, you need to show more, which is you need to show that there is no feasible alternative to comply with the standards, right, bracket, which they say will produce 17, but no feasible way to comply with the standards other than electrifying part of the fleet.
I don't see any evidence in the record, and the government hasn't pointed any in its briefs, that you can comply with this standard other than by some measure of electrification, and we can debate what that percentage is. And for major questions purposes, Your Honor, it's not just how much of a shift are they affecting here. Is it 10%? Is it a smaller number? Do we think that actually the momentum in the EV market moves as close to 17%? The power that they're claiming is the power to put zeros in the standards for all the EVs that they want to see on the roads, which is why they have now issued an NPRM and are moving toward finalizing a rule that says 67%. Nobody's going to say that by 2032, the market would otherwise be at 67%. The power that they're claiming is the power to mandate a transition. Now, this rule does that, at least in some measure, but if there were any doubt about the power that they're claiming, they've now sort of said the quiet part out loud.
The locution mandate a transition, there's a difference between mandating that you comply by use of EVs and predicting that that's the way you'll comply, even though you could comply in other ways. There's at least a real world difference between those two. You may think there's not a legal difference for our purposes, but there's actually a difference between those two.
Totally, they had always treated this as a compliance flexibility. It was something you could do but didn't have to do. And it was totally open to the government to do that here, and they could have defended in this court on the factual ground if they'd wanted to try. Look, this is just still a compliance flexibility. You don't have to have EVs to meet that. And we've got a lot of briefs in the case, and what none of them say is what I just said.
When we're considering, is it a must or is it a may, can we look outside the formal rulemaking record to other statements by government officials? I mean, as you know, there are cases about, statements by a president before he became president, right? Those don't count. Can we look to statements, orders by the president in an executive order and/or statements by the agency head in connection with the rules promulgation, or are those just like Trump versus Hawaii?
Oh, no. I think statements made before somebody got to the agency
but
are different. But can you look at what the agency is doing? Yes. I mean, as the Chief Justice sort of famously remarked, courts are not required to exhibit the kind of naivete that even ordinary citizens lack. Like, if you want to know what power the agency possesses, can you look at what the agency is doing with the power in the real world? Yes. I think it would be naive not to. I don't need that here because this rule forces electrification, but I don't think the court should stick its head in the sand for the power that the agency is claiming.
I guess I'm trying to tie down whether it really does force electrification, because the mere fact of a shift from 7 to 17, it's probative, but it doesn't conclusively tie that down for me.
So, I mean, they said in the rule, Judge Katsas, they're driving electrification and they're going beyond what the market would otherwise achieve. Right?
Driving is at JA5?
I believe, I'll have the exact
we'll
site on
check.
rebuttal.
I'll check it.
But it's either 5 or 51, but I'll have it on rebuttal. And I don't once you say, here's what the market would otherwise do, here's what we are requiring you, and the one is higher than the other, that's a mandate. We can call it whatever we want, but it is no longer an option. It is something that you have to do that you would not have otherwise done. And that's what makes this rule different. And it's why it changes everything for timeliness, for preservation, for major questions. It's different from what the agency has always done.
But do you agree that the agency could encourage electrification? What they can't do is mandate it?
I think I wouldn't, Judge Van, because I read 202A to say you set the standard for the class of vehicles that emit the relevant pollutant.
Right, and if the standard happens to encourage electrification, that would be okay.
I mean, that is an option they've given to manufacturers before. I would say the statutory text says, look at the class of vehicles that emit the relevant pollutant. Here you say that's not EVs. You say that's internal combustion engines. Set the standard for that class. Now, we would say at that point, you can't average, right? It's got to be individualized vehicle. But if you disagree with me on the averaging, then, we could sort of, once they've made up the power to average, we could talk about, can you use EVs as a compliance flexibility or not?
My
But they-
question is just, does your argument hinge on a conclusion by us that these standards force electrification? Encouraging electrification would be okay, right? You say they've done that before, and it's only a major question if they're forcing electrification, because that's your premise, that to force electrification would be a major question that Congress did not clearly authorize. But encouraging electrification, that would be okay, right?
So it hinges on a lesser version of that, Judge Pan, which is, it is a major question, and they don't have clear congressional authorization to force a transition to EVs.
Right.
Right. Now, I don't need you to conclude that they don't, right? I just need you to say the standard is clear congressional authorization, and whatever the best reading of the statute, it is not clear that the agency can do this.
Right. But if they're not doing that, they're not forcing, then there's no major question.
If it's just a sort of compliance flexibility in the way that it was in the past, we still have all of our arguments about averaging, and we still have all of our textual arguments on 202A, but I'll grant, if they're not forcing the transition, the major questions argument is a lot
I'm
weaker.
still not getting that now that we've distilled it in this helpful way between force and encourage, we keep coming back to the same thing where we are on the spectrum. If the agency sets a standard and what they say is, once we put this standard in, the way that people are going to comply with the standard is by choosing the electrification route because it turns out to be $1 cheaper to do that. They could do the other. They could do the other. They definitely could. But if we're going to predict what's going to happen, they're going to shift towards electrification because it's $1 cheaper. Is that forcing or encouraging?
If it is just an option for manufacturers as one among many, but they don't need to do anything with electrification,
And what I mean by don't need to is they're not legally mandated to do anything by electrification.
or practically mandated.
Okay, well, that's what I'm asking you then. If it's $1 cheaper to do it by electrification, does that mean they're practically mandated to do it by electrification?
I think here, because there isn't any way to comply other than by going to EVs, I don't think the court has to get into that hypothetical. Whether that's a practical mandate or not, I think the argument would not be nearly as strong, Your Honor.
What's the difference between mandated and encouraged if $1 doesn't fit on the encouragement line?
Because it's the same as West Virginia in the sense that the
Well, then there is no difference between mandating and encouraging.
I think there is.
What is it? Give me the hypo that's encouraging but not mandating.
Oh, if you offer it as a compliance flexibility, it may turn out that it's cheaper for manufacturers to move to EVs than it is to adopt some enhanced gasoline technology.
That's what I'm just saying. It turns out that it is cheaper
Right,
by $1.
It may be, but where
Maybe what? That may be encouraging or that is?
I think you could try to call that encouragement, sure. I think it.
What if that's not, then what is encouragement as opposed to mandate?
So I think there are lots of different ways that they have encouraged EVs. Congress has done it in lots of different ways, right? It's built charging stations. It's given tax credits to adopt EVs. There's a lot that Congress and the agency have done, both as a matter of sort of administrative fiat and statute to get people to move. I think what's new about the rule is it's requiring a transition. And to me, that looks
That's
just
what
like
I mean.
West
You
Virginia.
keep using the word requirement.
Because not because on its face, it legally says you have to, right? They're right in a sort of technical sense at page 55 of their brief. They did not say you have to do this. What they did was they put a lot of zeros in the standard such that the only way to meet the standard is to manufacture vehicles that they consider to have zero GHG emissions.
But it's not the only way to meet the standard. If you can meet the standard otherwise, but it's a lot more costly to meet the standard otherwise, then you would still say that that's mandating.
I think that you could still say it's mandated. I think it's a harder case than this one, where as a practical matter, it isn't possible to comply without moving to electric vehicles. Now, none of that, Chief Judge Srinivasan, is how the statute is supposed to work, right? Just to be clear before I sit down, the way the statute is supposed to work is you look at the class of vehicles emitting the relevant pollutant, you set a standard that's technologically feasible for that class, and then you determine compliance on an individualized basis. All of this only comes up for two reasons. One, they have folded vehicles into the class that shouldn't be there under 202A because they do not, in the administrator's view, emit the relevant pollutant. And then they have started averaging across the class in order to be able to say, well, some vehicles don't meet and others do.
So on that I get on the underlying arguments. On the major questions overlay, which is an essential piece of your, not essential in the strict sense, but a very pronounced feature of your argument. Is there a difference for your purposes between $1 cheaper to do it by EVs and actually there's no way to comply except by going to EVs?
I think there is a difference for the major questions doctrine between setting the standard in a way that the only way you can comply is by moving to electric vehicles more than you in the market otherwise would, and setting the standard in a way where some manufacturers might, as a compliance option, choose to adopt more electrification.
But that means, we keep coming back to the same thing. That means that some manufacturers are going to choose to do it even though they could do it for $1 cheaper? Is that necessary?
Again, not on this record and not in this case, but what I was trying to say was, in this case, it's an obvious mandate because they've outstripped the means of compliance with advanced gasoline technologies. If they were setting the standard in a way that you really could comply with advanced gasoline technologies, but you could also comply with electrification, and maybe electrification was preferable for some reason.
Including cost.
Including cost, I think the major questions argument would be not as strong as it is here. I think it would still be on the table, but I think this is the stronger version of it.
Okay, so that's how, I'm sorry.
Now, you're saying the strongest form of your argument for compulsion is, I think, it is not technologically feasible to comply with these standards without some degree of electrification.
That's right. You cannot do it with gasoline-powered vehicles.
But cannot is a technological issue. It's not.
That's right.
It's not a, effectively prohibitive because the economics.
You cannot squeeze enough improvement out of the internal combustion engine in the next 3 model years to meet the standard. You have to do one of two things: manufacture more electric vehicles or buy credits from someone like Tesla who manufactures.
And you understand that to be the upshot of this rule?
That is the upshot of this rule.
Okay.
In practical effect. That is what manufacturers will have to do.
When you say in practical,
I mean,
that
rule-
is a practical point, is that you practically
that's right.
cannot comply.
I just mean, to the extent that what the government says is, on the rule on its face, we didn't tell you what you had to do to
Yes,
comply.
I take that point. Yeah, and it's not a legal mandate.
That's right.
But
That's right.
it's-
It does not, they did not say on the face of the rule, thou shalt build more EVs. They set the standard in a way that you can only comply by doing that.
Technologically, you can only comply. Not most cost efficiently you can comply, but technologically,
Right.
you cannot meet it unless you go to electric.
Suppose EPA had found that electric vehicles emit greenhouse gases in tiny amounts because I forgot what, the air conditioners leak or something, and put them in the class on that basis, and then encourage/force electrification. What happened? How would you analyze that?
So one sort of factual quibble, Judge Katsas, and one legal answer. The sort of factual quibble is the substance in the air conditioning units are hydrofluorocarbons. They could have a hydrofluorocarbon rule, and they could sweep in all cars with air conditioners that use that, electric or non-electric. But it would just be a rule for the air conditioning units. It wouldn't drive electrification in terms of like tailpipe emissions. To your legal question, no. If they tried to say, look, we think EVs emit greenhouse gases in some way out of the air conditioning unit or what have you, and we're just going to dump them into sort of a suite of rules, including the tailpipe rule, even though we think they don't emit anything out of the tailpipe, right? Then I think they'd have a real problem. Now, if they want to start saying that electric vehicles do have emissions because they want to look at the whole life cycle, then I think that'd be a very different rule, totally different factual record and all the rest. The problem they have here is they've got a problem either coming or going. If they say they don't emit the relevant pollutant as they have, they're not covered by 202A, they're not in the class. And as soon as they say, well, they do emit the relevant pollutant, well, then the rule just doesn't look anything like this one. The rule treats them as not doing that. So I don't think they can defend it on the ground that in fact they do and therefore come within the class. The rule says they doesn't. It'd be arbitrary and capricious for them to now say, oh, in fact they do. They've got to make a choice one way or the other, and their choice was to say they have no emissions, we're not looking at the upstream stuff. As soon as they do that, they're outside the scope of 202A. And that, by the way, Chief Judge Srinivasan, is all the court needs to say to resolve the case. This is a major question under West Virginia and student loans. This is an old power, but in a new, very consequential way. And 202 is not clear. that you can use averaging in that way. That is the most straightforward way to resolve the case.
Could I ask you about the zone of interests issue? Because I think there's a pretty substantial argument that none of the petitioners have statutory standing because they're not within the zone of interests protected by the Clean Air Act. And in particular, the fuel petitioners. We have a precedent, Delta Construction, that suggests that they don't have statutory standing.
So, Judge Pan, I want to convince you the argument's not substantial. In Delta Construction, you were trying to increase the regulatory burden on someone else. In the two cases where fuel manufacturers, one a biofuel manufacturer in Energy Future Coalition, the other a traditional fuel manufacturer in Ethel, where they walked in and as here were contesting the regulatory burden on themselves, in both cases, this court said they were within the zone of interest and they could challenge emission standards in Title II. I don't see any reason to treat this case differently. I mean, then Judge Kavanaugh's reasoning in Energy Future Coalition seems to me exactly on point. He said Title II draws a balance between air quality improvement and productive economic activity because it asks you to measure technological feasibility and compliance costs, and we police that balance.
So it seems to me that there is a bit of a tension between Energy Future Coalition and Delta Construction. But Delta Construction is the earlier decided case. So to the extent that they would conflict, we would apply Delta Construction. And in both Delta Construction and Energy Future Coalition, we had fuel companies who, like this one, has an interest. Your fuel petitioners, their interest is always favoring fuel energy over electrical. And so for them, their interest really is one-sided and not aligned with the interests of the Clean Air Act.
So
So the Clean Air Act, like the interest of the Clean Air Act is to make the air more clean and preserve economically feasible options for the regulated entities, the automakers. The automakers in this case have intervened on behalf of the EPA. So it's not clear to me that the fuel petitioners' interests are aligned with the interests of the statute. And I think that this Delta Construction precedent seems to dictate that they do not have statutory standing, and it controls over Energy Future Coalition, which I think does support you.
So 3 quick points, Judge Pan. First, some automakers have intervened on the other side, as they say in their brief, because they've made investments and they don't want to in electrification, and they don't want to be at a competitive disadvantage. There are automakers like Toyota, Subaru that are not on the other side of this case. Second,
But they haven't intervened on behalf of your clients.
That's right. They're just not in the litigation one way or the other. I just wanted to say the automakers are not a monolith.
In terms of just deciding whether the interests are aligned, there's no automaker on your side.
Well, that's right, but the question is whether we fall within the zone of interest. So my second point was, I don't see a conflict between those cases on their reasoning, because what Delta says is, you can't walk in if you're not challenging your own burden and just complain that there's a lesser burden on somebody else. But what Energy Future and Ethel Corp say is, but if you're walking in as here to say the agency is imposing a regulatory impediment to the use of your product, well, you do get to sue. And then the third point is Judge Kavanaugh's reasoning for that. He did not construe the Clean Air Act as narrowly as I think the question suggests. He did not say, oh, this is really just about as much air quality improvement as you can squeeze out technologically. He said, if you look at Title II as a whole, it balances improving emissions with encouraging and allowing productive economic activity, and it asked the agency to balance between those two. If we didn't fall within the zone of interest, one side of that balance would go unprotected, excuse me, because you couldn't challenge the standards as being too strict. You could only, as the government says, challenge them for being too lax. And that, I think, would sort of turn the zone of interest into a one-way ratchet. And the Supreme Court's been very clear.
Well, if you were an automaker, you could challenge it because they are people who their interests are addressed by the statute. It seems to me, and I'd like you to address this, that Ethel was a different case, and Delta Construction even explicitly distinguished it by saying that's a case in which the interest being asserted was compliance with the statute. So if you are a company like a fuel company that wants to challenge this, if your interest being asserted is complying with the regulation, that's aligned with the interest of the statute. So that's a special case for a fuel company in the Clean Air Act context. In Energy Future Coalition, that case relied on Ethel without explaining why, but it didn't raise the same type of claim. So the way this all shakes out from my reading of the cases is that Delta Construction is the one that seems to directly address what your clients are trying to do here, and Delta Construction precludes statutory standing.
So I guess I'd say one broad and one specific thing. Broad thing, Judge Pan, is, at least as I read the cases from the Supreme Court and this court over the last 20 years, they've gotten progressively softer about what we used to call prudential standing or zone of interest. And the language has been ratcheted down pretty consistently to say you just have to be arguably within the zone of interest. It's not a demanding requirement. And so we're going to look at sort of the statute broadly understood, and that's what Energy Future did. And the second is, I don't think the court should sort of say, well, you're outside, but the automakers would be inside. I think all the government's arguments would apply equally to the automakers. If they were here saying, this is too hard, this is too expensive, the government would say, those are pecuniary interests. They're not in line with the statute. The statute just asks what's technologically
But the statute
feasible.
regulates automakers, so automakers they automatically are in. So, but you are sort of a component of combustion-driven engines. So can any manufacturer of a component of a combustion-driven engine have statutory standing from your view?
If they have Article 3 injury here, yes, the agency
We're
wants
not talking
to.
about Article
I
3
know.
standing.
I'm
just talking about zone of interests.
Yes.
Would any manufacturer, producer, anybody who manufactures a part for a combustion engine have statutory standing in your view?
And I just want to say, as long as they're independently harmed, yes, they would. Because what the agency
How are
is,
their interests aligned with the zone of interest of the Clean Air Act?
because the Clean Air Act draws a balance, as the Supreme Court said, no statute pursues its end at all costs. And it says, we do want to improve emissions, there's no question about that, but we want to do it in a way that's technologically feasible and that the industry is able to comply with.
Feasible for the automakers. Are they thinking about all the manufacturers of parts for combustion engines?
I don't know if Congress specifically had that in mind, but the point of the zone of interest test is, do you have an interest that's arguably protected by the statute? The agency wants to transition from one kind of vehicle to another. That may or may not hurt auto manufacturers. I think it will hurt some of them more than others, but it clearly hurts the fuel manufacturers.
I understand,
And
but the auto
these-
manufacturers are definitely in. I'm just trying to understand, what is the scope, in your view, of the zone of interests? Does it extend to any manufacturer, anybody who has any kind of an interest in a combustion engine or fuel or, gas fuel?
I think it extends to the entities that have an interest in the productive economic activity that this court has squarely said is one half of the balance that the Clean Air Act achieves.
So you think the Clean Air Act, the zone of interest, includes any kind of economic activity that is addressed by this act or is affected by this act?
It has anyone who has an interest in the productive economic activity that the act balances against improvements in air quality.
So that would be, though, anybody who has any kind of an economic harm or interest as a result of this act.
Well, I want to be careful, Judge Mann. Your earlier questions asked about anybody who's manufacturing components in cars. Yes, I think those manufacturers likely would be included. I think fuel producers are included. I don't want to say how far beyond that the zone of interest would go because I don't want to sort of speculate in the absence of knowing what the industry is. But those industries clearly police and the balance between productive economic activity and air quality that this court squarely said in Energy Future the act protects.
You say it's clear. I don't know if that's so clear because the Clean Air Act, it wants to clean the air, but they want to make sure that automakers can still be in business and be able to economically function. I don't think it's clear that they were thinking about all the other potentially affected industries that might go along with this. And Delta Construction suggests that they were not.
Judge Pan, that's not the way the court read it in Energy Future Coalition. The court there didn't perceive any conflict with Delta. I don't perceive any conflict on the reasoning of Delta. And I think more generally in terms of methodology, the court's been clear that when it runs the zone of interest test, it doesn't take sort of, too stingy a view of what the zone of interest is.
Well,
The Supreme
I do
Court has
wonder about
said,
that because that's the APA standard versus the other type, which is,
but
we're
Judge
not
Mann,
in the APA here.
I think the Supreme Court's been clear, when you look at the zone of interest, you have to look at all of the provisions in a given statute, how they interact, and you have to take a fairly broad bird's eye view to what the zone of interest is. And then you've just got to ask, are you arguably protected by it? Keeping in mind, this is not a demanding standard. It is not difficult to meet. It is rarely satisfied. I think it would be, given that this court has already said that a biofuel and a traditional fuel manufacturer fall within the zone of interest to challenge emission standards in this same statute, Title II of the Clean Air Act, I think it would be a really marked departure if this court kicked this case on sort of prudential standing or zone of interest grounds.
It wouldn't be a market departure from Delta Construction.
But again, I think I just read Delta Construction differently. Delta Construction said, not if you're trying to increase the burden on somebody else. What it did not say was, oh, you're here challenging the burden on you. That still doesn't fall within the zone of interest. Now, if it had said that, I agree. You'd have a conflict with Energy Future, but Delta doesn't say that.
So you haven't mentioned consumers in the exchanges you've had, and do you think that the consumers rise and fall with the manufacturers?
I think it's just as easy under the zone of interest. I mean, when you start looking at compliance costs, that's obviously manufacturers, but it's also consumers, right? And so if the consumers think that the standard that the agency has set will drive the price up on cars too high, here they say it'll be $1,000 per car, right? That's a pretty significant amount more for an average American to pay for an automobile. It seems to me they're arguably protected by the way that the statute says you got to balance what's possible with what's sort of economically or in terms of compliance costs a good idea. The consumers can police that balance, so can the fuel manufacturers.
What about the Ruckelshaus case that we decided? We said there that the Clean Air Act is not concerned with whether regulations pose costs the consumer should rightly bear if ecological damage is to be minimized.
So
We're not concerned with costs to the consumer. It's not in the zone of interest of the Clean Air Act.
So, Judge Pan, it's been a long time since I looked at Ruckelshaus. If memory serves, I think it was quite some time ago, before the more modern zone of interest cases, before Energy Future, before the court's decision in Lexmark. So I'll have to go back and look at it. Maybe it does have language that suggests that the Clean Air Act pursues only environmental quality and isn't concerned with anything else, but that's not right on the
It
face
says
of the act.
that. It's just, I think that within the the economical impacts that are addressed by the Clean Air Act, it's not any economic impact. It's very targeted to things that are aligned with the interests of the statute, and consumer protection is not part of the Clean Air Act.
Judge Pan, I guess I react very differently to that. I think that would be a sort of remarkable holding. If the agency said, we're going to drive, like here they say it's $1,000, but imagine if we're 5, 6, or 7,000. And if we're going to make the price of an automobile out of reach of the average American, it would seem to me fairly remarkable to say that consumers couldn't walk in and say that the agency had acted arbitrarily and capriciously in where they had set the standard, because they simply fall outside the protection of the act. The act says compliance costs, and it has to
It'd be
have,
a different cause of action. Arbitrary and capricious under the APA is different from what we're doing here.
or walk in and say they lack statutory authority to set the number that high, whatever the claim is. For zone of interest purposes, it seems to me, if the act says you have to balance improving air quality with how much it's going to cost in order to do that, and that cost is borne by manufacturers and consumers, I don't understand why only the automaker manufacturers and not the consumers who will bear at least most, if not all of that ultimate cost, wouldn't also fall within the zone of interest. That turns it into almost like an Illinois brick, sort of the first injured party cuts off the standing, and zone of interest has gone exactly the opposite way over the last 20 years.
Well, I just hear you saying that the magnitude of the cost is going to determine whether it's in the zone of interests, and I think the analysis is different. You look at the statute, what was the statute trying to do, and is this within the zone of interests? Even if the cost is really high, that doesn't put something into the zone of interests if the statute doesn't address that.
So I was just using the hypothetical to say, I think there are circumstances where it would get clearer and clearer that they would be within the zone of interest that Congress was trying to protect. And if I'm right about that, as one goes through the hypotheticals, then I think I'm right here. Once you're in the zone, you're not in the zone for only some purposes.
Make sure my colleagues don't have additional questions at this time. We'll give a little bit of time for rebuttal. Thank you, Mr. Wall. Ms. Pettit.
Thank you, Chief Judge Srinivasan, and may it please the court. I've heard a lot of questions today about whether the EPA was merely predicting whether this would increase electric vehicles or actually mandating it. To use the words of the EPA itself on page 60 of the joint appendix,
Sorry, which page?
page 60 on the 60, right-hand column halfway down, compliance with the final standards will necessitate greater implementation and pace of technology penetration, including, skipping down, further deployment of BEV and PHEV technologies.
Right, but it says including. And so it does that, I don't read that necessarily to me, and we can certainly ask EPA about that. I don't read that to mean that one of the things that has to happen is BEV and PHEV. It could mean that there has to be changes, and one of the potential changes would be BHEV and
If this were the
BEV and PHEV. Sorry, I'm getting the letters wrong.
Yes, Your Honor. If this were the only sentence that was to that effect, I would agree. But I would point to look for a prediction about what is going to happen is on page 5, and I'm afraid I didn't bring that page up with me, so I can't point you exactly on where the page is. But it's talking about how it's anticipating at that point the increase to be electric vehicles, and that it's driving electric vehicles on page 51. So the EPA has said on a number of occasions this rule will lead to, or will necessitate again, this transition.
So do you read those to mean that they will, yes, they've made the prediction, there's no doubt, because I think the gap between 17 and 7 is proof positive that the prediction is there. There's no doubt about that.
Yes, Your Honor.
Do your statements mean that the only way, what the agency is saying is the only way that manufacturers can come into compliance with the new standards is by shifting to EVs?
Read in context, yes, Your Honor. The EPA really can't deny that either. It cannot deny that it's part of the administration's larger policy to force the electrification of the fleet, because not only was it announced on the same day as Executive Order 14037, that order is referenced on JA4 of the Joint Appendix. So read in context, this is a mandate. Now, whatever the merits of that policy, it is not a permissible policy end under Section 202 of the Clean Air Act, and the EPA has pursued it through impermissible means for among the reasons, in addition to the reasons you were just discussing with my colleague, that they relied on a cost and benefit analysis that picked and chose between facts and assumptions that maximize the putative benefits while ignoring the very real costs.
So under your argument, does it have to be the policy end? What if it's just incidental to what they're doing? What if incidentally, like it requires some electrification, but they're just setting the standard, which is what they have to do under the Clean Air Act?
Under our argument, it doesn't matter, because whether they did it by accident or on purpose, they have mandated the transition to and the fundamental rewrite of major industry, which since Brown and Williamson and reaffirmed a couple of years ago in West Virginia against EPA is a major question reserved for Congress.
What if it requires 1% electrification? Does it matter the degree of electrification to make it a major question?
So if it's just 1% electrification, it would be difficult to assert that that is a true mandate.
Okay, so for 5%, would that be?
So it's hard to say if there were and perhaps to clarify my prior answer, if the EPA were to say you are required.
No, I'm working within the framework that we have under the Clean Air Act. They're setting emission standards. It incidentally requires electrification because it's a real world factor. And it just requires 1 or 2% electrification. Would that be a major question in your view?
If there were no other functional way to do it, then probably, because again, the Congress has considered.
No functional way to do what?
If there were no functional way to that is a hypothetical that's difficult to imagine the way you would write that regulation. But if it were possible.
The regulation is I'm setting this standard. It's a standard that to comply with it, incidentally, we contemplate that there will be some electrification, 1 or 2%. Is that a major question?
At the present time, it's not a major question because that already exists in the marketplace. And it's what is driving it is the push past
so
the
you
market.
agree that setting a standard that requires some electrification, as it has in the past, would not be a major question?
So
it's only if there's a lot of electrification.
Setting the standard in a way that can be complied with existing technologies is not a major question. What makes
That's not what I was asking you.
So I'm not sure I understand if you could rephrase the question.
Sure. My question is, all the EPA does under this provision of the Clean Air Act is set a standard. And we're talking about the stringency of the standard. And I understand your argument to be, if you set it at a very stringent level, which requires automakers to electrify, that would be a major question because you don't have the authority, EPA, to require electrification. But I understood your prior answer to me to be that if I if I'm the EPA and I set the standard and it happens to contemplate a little bit of electrification, 1 or 2%, that wouldn't necessarily be a major question.
If it happens to contemplate that, no, it's taking into account reality. If it is forcing that, that's when it becomes a problem, because Congress has considered an electrification mandate at a below 100% level 4 times in the
At what
last.
percentage does it become a major question? If at 1 or 2% it does not, and at 17% it does, where's the line for a major question?
The line is where it becomes a mandate, because Congress has considered a mandate 4 times in the last 5 years. So the question.
But if it mandates 1 or 2%, you said that wouldn't be a major question.
I believe I clarified my answer to be if it mandates, if the standard, because you've asked the question a couple of different ways. If the standard contemplates, it's not a mandate, it's not a major question.
Okay, if let me clarify, I'm sorry.
Yeah.
So if the standard set requires 1 to 2% electrification, is that a major question?
Under the way that the court has interpreted that question, yes, because the way
It
that
would be. That's huge and extraordinary power by the agency
yes,
in our
because
current world where there's electrification happening anyway?
yes, Your Honor, because the frame of the doctrine is not how the power is, and this is going to the Nebraska case is probably the best example of this. It is not the way the power is wielded. The doctrine is a guard for fundamental constitutional concerns about the separation of powers. It is the nature of the power claimed, and whether they are claiming an ability to mandate 1% or 100%, that is a power that is a fundamental legislative choice reserved to Congress.
So I asked your friend the same question. So what do you think the agency should do? They should decide what the standard is that would protect public health, and they should ratchet it down to make sure that they're not relying on electric vehicles? What are they supposed to do?
I would point your honor to section 202A3A little Romanet 1, where the EPA is given a variety of different factors that it has to balance in the Energy Coalition term of that phrase. And so this is not an instance or a public health law entirely. They are not entitled to set, well, we think it would be ideal to have X number of tons of carbon dioxide. They can set the standard based on technological feasibility and upon other considerations set out by the standard.
But it's all feasible. This is not one of the factors that's in
So
the statute, avoiding electrification, because it's a major question. So I'm just wondering, like, how in practical effect you think the agency is supposed to do its job while taking into account this issue?
So the agency is supposed to do its job by taking into account those statutory factors. And I think that perhaps the better way to answer your honor's question is to point you to pages 2609 and 2610 of the West Virginia case, in which the court said that federal agencies are not entitled to short circuit the political process by using broadly worded general delegations of power, even where there is a plausible textual basis. So I don't dispute, your honor, that under the strict construction of the statute, they technically could do this, but that is not the common sense understanding of how Congress is understood to delegate matters of significant economic and political concerns, in the words of Justice Barrett's separate opinion in the Nebraska case. So they are to set the standard based on the overall context of the statute, which was written at a time and written, frankly, in terms that contemplate an internal combustion engine.
It also contemplates electrification, though.
The statute does not contemplate I'm speaking to section 202A,
It doesn't require you to ignore electrification.
It does not speak to electrification one way or the other, but that is the problem with the major questions doctrine for the EPA, because this is a very complicated issue that requires balancing a lot of different interests, which is why in the Infrastructure and the Infrastructure Act that my colleague referenced, the Congress commissioned a report about 16 different topics, because Congress recognized that this impacts not just cars, and it also impacts the grid, and it impacts oil companies, as well as many other factors. And balancing that is a fundamentally legislative task that Congress hasn't done yet. And so from a major questions perspective, the EPA cannot short circuit that process using this old broadly worded provision.
Can I just ask one clarification? For the 1% hypo, I take it that your argument is not that 1% every time a mandate of 1%, just to be clear. A standard that's going to require a 1% shift in favor of electrification. Your argument isn't necessarily that any time there's any iota of a mandatory shift, that's enough. I assume your argument is that anytime there's a mandatory shift of any iota, if there's no distinction, there's no stopping point to that. In other words, the agency is saying, yeah, this time we're doing 0.5%, but the logic of what we're saying would take us all the way up to 99.
Precisely.
That would be. But if there were another world in which there was some other consideration that would cap it at 1%, then it might not be a major question, even under your view, I take it.
Yes, Your Honor.
Okay,
But
so-
it's the nature of their power, and the power that they are claiming here is the power to force 100% transfer, and Congress has not given it to them.
Which is why I think your case depends on this question of can you include electric vehicles in the class? Because otherwise, if we're just talking about 1% versus 17% versus 7%, it just feels like a question of degree and how many notches can they turn up the knob. That doesn't feel major. That feels like arbitrary and capricious review. So it just has to be that there's just a conceptual difference in kind when you put into the class this non-emitting, different kind of thing, which is the
Certainly, Your Honor.
electric car.
And what I would point, Your Honor, that might help with that question is I believe it is subsection C.
You agree? I mean, that wasn't
was-
entirely a friendly question, right? It's, you need the piece about
I think
electric
that
cars being in the class.
I think that the electric cars have to not have been contemplated by 202, is how I understood Your
Right.
Honor's question to be. And we don't think that it is, and we don't think that Congress has clearly spoken to it precisely because, as I was discussing with your colleagues, it doesn't mention electric cars at all. And by contrast, and I would point this court to the language in Brown and Williamson, where the Food and Drug and Cosmetics Act or in general terms included it, but Congress spoke about tobacco in a much more specific way. And this is very analogous to that because the Clean Air Act can be interpreted to include electric cars, but it shouldn't be in light of, for example, 26 USC 30D, 42 USC
Well, let's
1321.
before we get to the FDA versus Brown and Williamson point about other statutes, let's just talk about this one for a second. And one feature of this one that may cut against you on this point is a combination of two things. One is this scheme is all about motor vehicles. Motor vehicles is a defined term, and the definition includes electric no less than combustion engines, right?
Yes.
And then the other is right in the provision we're talking about. EPA gets the authority to define the relevant classes within that definitional category.
So what I would point your honor to about that is actually subsection E, not C, as I said earlier, where it's talking about new power or propulsion systems.
I'm sorry, where are you? E of?
Section 202 or 7521 in
Right.
22 USC, where Congress seems to be contemplating how
Sorry, this is new power sources?
new power sources
Okay.
or propulsion systems.
Right.
So Congress in this section does not seem to contemplate that the EPA is just going to squish together all forms of motor vehicles. The Congress seems to be saying in this section that the administrator is to consider them separately. And that is how I would respond to your honor.
How does it say that in this provision? It says any class or classes of new motor vehicles or new motor vehicle engines which in his judgment cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare.
I was looking at section E, your honor, which says that in the event of a new power source or propulsion system for a new motor vehicle or new motor vehicle engines is submitted for certification, skipping some parts, the administrator must postpone certification until he has prescribed standards. So this seems to contemplate different standards for different new propulsion systems. And electric vehicles are a propulsion system that may have been in extensi when the law was passed, but it is certainly not in the form that they currently.
But that was certification. Is that the ability to regulate such vehicles?
So certification is the way that the standards are enforced. The standards are set, and then new vehicles have to be certified that they meet those standards. So this allows the administrator to postpone that certification process to set standards when there's a new propulsion system, which seems to suggest it should be in a different class. But the court doesn't need to necessarily get to that point because I think that it can resolve on the major questions doctrine, as my colleague suggested. So
They could still be in the same class, I guess, right? Because it could be that when you have a new propulsion system, is the authority to postpone certification, but that doesn't mean that it's not also part of the equation under A.
So I would make sure that Your Honor would ask Your Honor to pose that question to my colleague whose brief covers that topic in much more detail. But the problem that I see with that is the way that, returning back to A1 that Judge Pan was just asking me about, the way that it's written is in terms of standards applicable to the emission of any air pollutant. And then it dropping down 2 lines, such standards, referring to the same standards, shall be applicable to such vehicles and engines for their useful life. So if this vehicle is not emitting the relevant pollutant because it, for example, doesn't have a tailpipe, and that's where carbon dioxide comes out, then it couldn't be in the same class because it's not, in his judgment, cause or contribute to air pollution from that standard, from that pollutant. Because pollutants are not one size fit all.
I stopped you, you wanted to go to other statutes like in Brown and Williamson, the statutes other than the FDCA. So is that like the RFS, right, scheme which presupposes the availability of liquid fuel? Is that what you're?
That is certainly one of them, but that actually wasn't what I was referring to.
Okay.
So what I was referring to was when Congress has dealt with electric vehicles, again, it has rejected a mandate 4 times in the last 5 years. Instead, it has picked other options. It has created a tax credit in 26 USC 30D. It has created demonstration projects in 42 USC 13281, and it has allowed for the development of infrastructure to permit their growth. It has encouraged, it has not mandated, and as the Supreme Court noted in the MCI case, the court and the EPA is not just bound by Congress's ultimate or desired policy choice, but by the methods that it chose to use. And here, the Congress has never chosen to mandate, and it has never allowed EPA to do so.
Can I ask you, for your view, if the shift to electrics is, no, let me put it the other way. If it's technologically feasible to comply with the new standards without shifting to electrics, but it just costs a lot more to do it that way, would you agree that that doesn't then tee up a major question? That it has to be technologically only achievable by going the electric route?
As long as it doesn't cross the line of 202A3A Romanet 1, because there is a point where it has become so costly that it's not feasible, and it goes back to what I was talking with Judge Pan a few minutes ago, where they're just turning it into a public health statute instead of one that balances. So if it satisfies that, then it wouldn't be a major question just for it to be less expensive. It'd be as in my friend's terms, a compliance.
So prohibitively costly.
Prohibitively costly would, I think, run afoul of that other provision, because as this court noted in Energy Coalition, it's a balancing act.
But if you just look at the statute on its face, put aside major question, put aside electrification, it seems like the focus of the statute is on technical feasibility.
Yes, Your Honor.
Provision you just read and the one in A1 about allowing time for the new technology to be developed and such.
The provisions that we were just talking about, because I've learned my lesson about trying to interpret Your Honor's questions ahead of time. But yes, the provisions that we were just talking about are talking about technological feasibility in a way very similar to what the statute at issue in West Virginia against EPA. And technological feasibility in that case was not moving between major sources of electricity, and technological feasibility here isn't moving between major propulsion systems. I have a number of arguments about the arbitrary and capricious issue, but I am way over time. So unless you have questions.
Thank you very much for your argument. Hear from EPA now, Ms. Chen.
Good morning, and may it please the court. Sue Chen for the United States. With me today are Daniel Durdke from the Justice Department and David Orland and Seth Nolbaum from EPA. To protect the public from harmful motor vehicle emissions, Congress directed EPA to reduce emissions through technology in 7521A, and that's exactly what EPA did here. Before we can get to the statutory arguments, I'd like to first address the threshold questions. First looking at exhaustion, the time bar, and then I'll speak briefly as to zone of interest. Petitioners waive all their statutory arguments for three reasons. First, they fail to raise these issues with reasonable specificity as required by 7607D. Second, the regulatory elements that petitioners object to were established in the 2010 rule, and so the challenge is time barred. And finally, EPA expressly said that it was not reopening these elements. The court should strictly enforce 7607D's mandatory exhaustion rule and hold that petitioners waive their statutory arguments for failure to exhaust. In response to our exhaustion argument, the field reply brief on page 9 offers 3 snippets from the record where they supposedly raise these issues, but those 3 snippets are just vague references to EPA's authority in the context of other discussions about other issues. So the best example they offer, and it's not very good, is JA 642, which is a discussion about the Energy Independence and Security Act and the Renewable Fuel Standards. And the commenter notes EPA's authority to set standards under 7521A1, but then says that EPA's encouragement of zero-emission vehicles at the expense of internal combustion vehicles is an overreach of authority inconsistent with the statutory design of the Clean Air Act.
So I might quibble with you a little bit on which one's the best. It may be that the trading one at least speaks a little more specifically, but if we just, for present purposes at least, if we put aside reasonable specificity, I think they seem to be placing the principal focus not on the fact that, yeah, we did it with reasonable specificity, but that we didn't need to do it at all because this is a presupposition. This is the kind of presupposition that the agency just has to address every time.
So they're relying
key
on,
assumption.
Yeah, they're relying on key assumptions doctrine. And that doctrine has been displaced here by the Supreme Court's 2016 decision in Ross v. Blake, which held that mandatory exhaustion statutes are mandatory and there's no room for judicial discretion. This court then applied Ross in Fleming v. USDA and held that when a statute imposes a mandatory exhaustion rule, courts can't excuse the failure to exhaust no matter the reason. And so we ask that you follow Ross and Fleming and apply 7607D's exhaustion rule as written, which recognizes no exception for key assumptions.
So suppose there is, I know I'm familiar with that line of cases, but suppose, yes, for obvious reasons, but suppose that the key assumption doctrine subsists, it persists. What's your answer to their argument? I'm not saying it necessarily does, but just for purposes of fleshing out the principal focus of their submission as I understand it.
So the statutory issues that they're raising are not key assumptions in the context of this rule. This is a well-established regulatory framework that EPA has used in every single vehicle greenhouse gas rule, and EPA specifically said it was not reopening those structural elements. So it can't be that every time the agency tightens its standards, that somehow reopens the fundamental structure to challenge. That would deny automakers the predictability they need to be able to run their business.
Why? So your argument is that you're melding together the fact that it's happened before with key assumptions.
Many times.
Yeah, with once or a million times. I'm just saying that there's that you're baking that into key assumptions, and where I haven't seen that done before. I mean, I'm not saying that there's not a reason to do that or that doesn't make sense. I'm just saying that that seems like something. I don't recall a key assumption case. There's not that many of them, but I
Right.
don't really recall a key assumption case that specifically treats with this question of what happens in a situation in which the rule has actually come up a few times already with the same features baked into it. Do you
So-
still have to redo the key assumption every single time? And your answer
So-
is no.
Right, especially when EPA specifically said it was not reopening these elements. And I think a helpful case might be Hispanic Affairs Project via CASA. This is 901 F 3rd 378, which was decided in 2018. And there, the key assumption, there was a key assumption, but the court was stressing that this was the first time that the agency had made that assumption in this, or it was the first time that EPA or agency was regulating in that area. And so there was no prior regulatory source to be found for that authority. And so I think it is important that this is not the first time that the agency was doing it.
But what if it was the first time? I take that point. I think I understand that submission that key assumption works differently. It essentially gets turned off when this is a repeated exercise. But do you have?
I think we would have a weaker argument.
Mhm.
Can I ask you to focus on just the major question piece?
Sure.
So for preservation, so suppose they say the argument they make is lack of statutory authority for this rule to force electrification. Without the major question overlay, the question would be whether the statute contains authority. With the major question overlay, the question is whether the statute contains clear authority. They don't specifically mention major question. Is that a forfeiture of the major question point?
We don't
Or
think,
is that just kind of like a standard of review that's encompassed in the statutory question?
so I think the major questions doctrine is a principle of statutory interpretation, and they don't need to say the word major questions doctrine in their comments. What they do need to do is to present the underlying interpretive issues that they're now raising in court, and they haven't done that.
And you think that I get the point about averaging and trading and stuff, but you don't think it was fairly preserved in this record, the argument that EPA lacks statutory authority to force electrification?
No, they didn't say anything about forcing electrification at all. There's nothing about, averaging in EVs is somehow means that this rule is now an effective EV mandate. We don't have any of that in the record.
But you do make the argument, I thought, in your brief, maybe you can point me to it or disabuse me of this misimpression, but I thought you do make the argument that there was an independent requirement to preserve, whether you call it major questions or not, there was an independent requirement to preserve the argument that we're now calling major questions in the rulemaking process, and that wasn't abided by.
They needed to raise these particular interpretive questions.
Right, but not just that they needed to, address averaging and electrification, but that they needed to address major questions. In other words, the need that because of the degree to which it's been done here, or whether you call it a difference in degree or difference in kind, what's happening here is something that's so significant that it brings into play this doctrine to the effect that there has to be especially clear authorization to do it.
I don't think they needed to say this is major questions because of X, Y, Z. They do need to preserve the underlying legal and factual predicates of the arguments that they're now making, including that the statute doesn't allow EPA to do averaging, the statute doesn't allow EPA to include EVs, and that these standards are so strict that they basically force the use of EVs. Those are the things that they should have raised in comments.
I'm sorry,
Right, I
you're
thought
you're
that-
conceding, I'm sorry, you're conceding that they didn't have to exhaust the major questions issue?
They didn't have to say major questions doctrine.
Well, they don't have to use the words.
Right.
But is that all you're saying? Because I'm just reading from your brief. This is page 39 of your brief. Let me make sure I've got the brief in the right case. Yeah? Okay. So I think it's that there's two cases here. They can run together in one's mind. Petitioners also fail to articulate their view that the level of projected electrification and indirect effects on the economy triggers the major questions doctrine.
So I think we meant to say that they didn't say that because their argument is, the major question argument they're making is that it's a major question because this is an EV. And they didn't say in the comments that the level of, or the stringency of the standards means this is an EV. Not that this triggers a major question.
So why do you think they don't need to raise major questions specifically? Because that would put the agency on notice that they need to address that.
Because major questions doctrine is a principle of statutory interpretation. I don't think they needed to raise that in comments. And certainly when they raise interpretive issues, that is an issue of statutory interpretation that the agency would have to deal with. And so we're focused on giving the agency the opportunity to deal with these particular interpretive issues at the comment stage, rather than, you know, what this means on the major questions.
So you're just saying you're fine that you may not have known that you needed to point to particularly clear statutory authority. That doesn't matter.
We don't think they needed to raise the major questions issue.
Okay. And can I ask you on, although I don't want to shift precipitously away from the threshold questions, on the ultimate, the substantive questions that are before us, do you agree that the EPA rule practically mandates electrification?
No.
Do you agree with that?
No, because there are, in fact, internal combustion vehicles that can meet the standard without EVs. As Judge Pan points out, there's Subaru. So there is no, so the standards do not, in effect, mandate anyone to use. Now, automakers want to use EVs because they provide a cheaper compliance path, but that's not the same thing as a mandate.
The rule doesn't mandate on its face.
Right.
But is it technologically feasible to meet these standards without electrifying?
Yes, and Subaru is the evidence of that.
And you don't think that, you think anybody could be a Subaru?
We think this shows that there are internal combustion vehicles that can meet the standard. Whether people want to do that, whether people want to be Subaru, is a whole separate issue.
Okay, so I mean, it seems to me that you heard both arguments on the other side. It seems to me there's a fundamental disagreement on whether the rule, as a matter of technological feasibility, requires electrification.
And this is why it was important for petitioners to have raised this issue before the agency. The agency could have looked at its modeling and crunched the numbers and given us a definitive answer one way or another, but they haven't. And so the court shouldn't draw a favorable inference based on the absence of this clear analysis in their favor.
Do you think that the case would look different if the only technologically feasible way to comply with the standard were to go down the electrification route? Do you concede that that would be a major question? It would pose a major question?
No. So let me answer. So to answer your question, the case could look different in that if you agree with us that this rule were not an effective EV mandate, then I think you have an easier path in saying petitioner's whole argument is predicated on this being an EV mandate. It's not, so we don't need to resolve other issues. If you think that this were an EV mandate, it's still not a major question because the major questions doctrine, as I said, is a principle of statutory interpretation. So the major question inquiry here is not whether EPA can set standards to force EVs. That's not a question of statutory interpretation. The relevant interpretive questions here are whether EPA can consider all feasible technologies when setting standards, whether it can set standards using averaging, whether it can define classes to include EVs. And none of these questions qualifies as major because these are things that EPA has been doing for years. So there's no transformative claim of new authority.
But what, go ahead.
Suppose EPA did set a standard under which the only technologically feasible means of compliance is 100% electrification. Do you assert that power?
You mean, right?
Would that be consistent with the statute on your view?
Yes, because I think we need to draw a distinction between having authority to do something versus using that authority in a reasonable way.
I
And the
understand there
statute-
might be arbitrary and capricious challenges, but your theory would support 100% electrification rule, mandatory in the sense that that's the only technologically feasible means of compliance.
So I think that would come about if EPA were to set its standards at 0. And that's
The
assuming
standard, sorry.
at 0. And that's assuming that there are no technologies like carbon capture that could be installed on internal combustion vehicles. And in that, so then the question is, does EPA have authority to set standards at 0? And the answer is yes, because 7521A authorizes.
If they did set it at 0, would that trigger the major question doctrine?
No, because, let me just go back and clarify.
Okay.
The answer is still no, but when it comes to a zero emission standard, of course, EPA has to have the record to support that standard. Now, I think your hypothetical posits whether EPA could, in theory, set a standard that we might see right now as extreme on this record. But that's not enough to trigger the major questions doctrine, because you can always imagine some extreme use of any regulatory authority. So for example, the Clean Air Act authorizes EPA to set national ambient air quality standards. And with the right hypothetical record, those standards could be 0. But no one,
I mean, why is it extreme on your theory? Your theory is that electricity is just another kind of technology. It's like thinking about a catalytic converter or something.
I'm not saying it's extreme in general. I'm saying it might look extreme at this point. And this is why I assume we're talking about a hypothetical. But if EPA, whatever standards EPA sets, it has to be supported by the record at that point.
But I mean, it's going to be easy to support. The electric vehicles are so much more efficient. You say electric vehicles are technologically feasible. If you electrify to 100%, you can get, I don't know what the number is, 100 miles per gallon standard, whatever it is. You set the, you say the scheme, the only standard on the face of the statute is technological feasibility. And there you go.
that would still not trigger the major questions doctrine, because again, the question is not about whether EPA can set a 0 standard. You have to frame it in statutory terms. And the question is, can EPA set a standard that considers all feasible technologies, which it would have to do no matter what standard.
Can you just make sure you point the mic to you? Towards
Yeah,
it?
it's-
Yeah.
Is this better?
I think it will be. Let me just make sure I'm understanding where we are in the argument. So as a matter of the argument's architecture, this exchange is assuming that we're past an off-ramp that's a different one, which is that we're not even talking about mandating as a practical matter electrification at all in this rule, because this rule just doesn't do that.
Right.
And so we don't have to engage with the question of whether we would, in theory, have the capacity to mandate it to 100%. But if you go down that road, then I guess I have the same question. Oh, go ahead.
Meaning to just put aside the
Yeah.
question what this rule does and ask about the logic of
The assertion of
agency's
power.
position, right?
Of potentially setting a 0 emission standard.
So wouldn't
But-
42 USC Section 7521A2 come into play? Because that says that the standard shall take effect after such period as the administrator finds necessary to permit the development and application of the requisite technology, giving appropriate consideration to the cost of compliance within such period.
Right, these are built-in guardrails for EPA's authority in A1 to set standards at the level they choose.
So if the EPA followed all of the statutory directives and guardrails, it could theoretically set a standard that meets these requirements.
Exactly. And the fact that it could set the standard to 0 doesn't trigger the major questions doctrine because, again, there are lots of standards that agencies can set, and they, in theory, could all be set to 0. It doesn't mean that all those issues are major questions because major questions doctrine is limited to extraordinary cases. Not every time an agency sets a standard.
Right, it depends on what the standard does. And it just, if EPA just announces, there shall be no more gas-powered vehicles. All vehicles from year 2026 on have to be electric vehicles.
That would not.
That sounds kind of major, just as a
Yeah, you think that
descriptive
might be a
matter.
big deal?
Right, but again, the major questions inquiry is not about particular outcomes, it's about statutory questions. And so the statutory question is, can EPA, when it's setting standards, consider all feasible technologies? And as just Pam points out, if it's feasible, then that is the authority that Congress gave EPA to act.
You do need, I'll give you, you do need some element of novelty. But, I mean, a big part of the major questions doctrine is the economic and political significance of the power asserted. And that seems easily satisfied.
But again, the major questions doctrine does not revolve around particular outcomes. You have to look at the statutory questions.
You look at the scope of the power asserted. And I mean,
scope of the
it may
power-
be that you have that power, but that's an application of the doctrine, not a reason for
And the
treating
scope,
a 100% electrification mandate as just another standard.
and the scope of the power asserted is the ability to set standards. And I think especially in this case, when you're looking at potential collateral consequences, I mean, Congress intended for and designed these standards to have collateral consequences on things like fleet makeup and supply chains. And so that's just the nature of standards that push for technological innovation and adoption in something as ubiquitous as motor vehicles. The fact that EPA's standards can have effects on other things is not a reason to think that EPA acted beyond what Congress could reasonably be expected to have.
And in the other side has invoked West Virginia.
Yeah.
And so in the hypothetical situation, after you've gotten past the fact that under your view, this case does not involve a mandate at all, but if we're in mandate land, then in the hypothetical situation in which the mandate is 100%, that it's just, we're not doing gas vehicles anymore, gas-powered vehicles anymore, we're only going to do EVs, then the argument from the other side, of course, is going to be, well, that's West Virginia exaggerated because that wasn't a complete shift. It was just saying you shift from 27 to 36 or so, I can't remember the exact numbers, but you shift in some measure. We're talking about a complete shift. And I guess the difference at that point is just what you define as the relevant denominator. Is it motor vehicles or is it motor vehicles that are gas-powered?
And it's motor vehicles. I mean, the big difference between this case and West Virginia is that Congress set a completely different regulatory scheme here. So the problem in West Virginia was that EPA had no authority to regulate renewable plants. And so when the Clean Power Plan was shifting electricity production from coal plants, which is a regulated source, to renewable plants, that completely changed the regulatory scheme, which was to reduce emissions at regulated sources and not to shift away from them. Here, 7521A authorizes EPA to regulate motor vehicles, and they're defined functionally without regard to their propulsion source.
And motor vehicles are the only sources that we're talking about here. So in other words, we start off with motor vehicles. Thanks to the rule, we end up with motor vehicles that have emission controls on them. And that is EPA acting within the heart of the regulatory scheme that Congress set up, which is to reduce harmful emissions by putting emission controls on motor vehicles.
So you think the
And-
analog to, I think the baseline in West Virginia was power plants, right? And the idea was, well, if you're shifting from coal to a different kind of source, then that's a shift that is major. And you would say that relevant baseline here is modes of transportation, so it would be shifting from cars to bikes.
Yes, that would be the.
But as long as you're within the scheme of cars,
Right.
or not just
Right,
cars,
because-
just motor vehicles, yeah, right.
Right, because-
Non-passenger vehicles.
So this idea of shifting from gas cars to electric cars, I think that draws a false distinction between these two types of vehicles. And it's one that 7521A does not recognize. Because remember, it talks about motor vehicles. So the shift from electric to gas is not relevant as a legal matter under 75.
Okay, so can I just, can I bring us back to non-mandate land? Because the first fork in the road is between mandate and non-mandate. And then you think this is a non-mandate case. Then in the non-mandate world, is there a difference between a situation in which the agency thinks it's technologically feasible to comply without shifting to electricals, without electrification? It's still technologically feasible to do it through traditional engines, to do that. But the agency is actually not agnostic as between those two possibilities. It actually wants to bring about a shift towards electrification. Do you see a difference between what the agency wants to do? Because some of the statements that have been pointed to that are outside of the rule itself, but that are various officials commenting on the result of the rule, point to a desire, a hope, an aspiration backed by the rule that this is going to engender a shift. And that seems different to me, at least conceptually. There's a distinction between that and, yeah, it could be a shift, but the agency, qua agency, is just agnostic as between them.
Agency is agnostic as between specific technologies. When tightening standards, of course, EPA is pushing for automakers to use more emission control technologies, period. And of course, that includes electrification. Now, if the shift means that automakers are going to use better and more efficient emission controls, that's great. But at the end of the day, what EPA is worried about is automakers meeting their fleet average standards in however they could.
So then how do you, we were looking for the various statements in the rule itself. If we disregard statements outside the rule, we're looking at the rule itself. So there was a statement on page 60 of the joint appendix, the third column, 74493 of volume 86 of the Federal Register. Compliance with the final standards will necessitate greater implementation and pace of technology penetration through MY 2026 using existing GHG reduction technologies, including further deployment of BEV and PHEV technologies.
Right. And that's just saying the standards have gotten tighter, more technologies will be used. Those technologies include electrification. It's not a mandate to specifically use more electrification.
And it's not a recognition, you don't think, that the only way to comply is through at least some use of electrification.
Right. It just notes that that electrification is an option.
People might make that choice.
Automakers
And actually, you're predicting, and you don't deny that the prediction definitely is that more manufacturers will make that choice under the rule than without it.
that is the penetration analysis, yes, but that might not come.
No, I'm not sure we should be reading statements in the preamble as if they were statutory text, but let me do that for a minute. I read it very differently, and I was surprised by your answer that this is not a mandate. Because it says compliance will necessitate technology penetration, including further deployment of electrification.
Right. So there are other kinds of emission control technologies that are on the table.
Electrification is included in the technology penetration that will be necessitated
Right.
by
And
compliance. It
what's-
seems like the most natural reading of this by far is the standards will force technological change, and that part of it is unexceptional, but one part of that change will be electrification.
Right, because electrification is one of the emission control technologies that can be used for automakers to comply with the standard. It's not the only one that can be used. What EPA is mandating with this rule, in effect, is more emission control technologies. It's agnostic as to what kind it is.
In other words, when it says including electrification, in your view, what it's saying is that's likely going to happen. Our tables are predicting that it's going to happen,
Sure, because
but it's not the only way that it can happen.
that's right. That's exactly right.
Is there anything that precludes the EPA from contemplating penetration that includes electrification? Because it seems that it would be very artificial to try to set a standard to avoid electrification in order to not spark a major questions challenge, which I think is the bottom line of what your friend on the other side is suggesting. That the
Right.
EPA must avoid electrification because any kind of requirement of electrification would spark a major question.
Right.
I don't see any support for the idea that the EPA cannot consider or even require some amount of electrification. It could be on an extreme level, we might be getting into a major question land, but in just setting a run-of-the-mine emission standard and expecting that to mandate some electrification, that doesn't seem to fall outside of what the statute requires, or does it?
Right, right. And in fact, A2 directs EPA to consider the feasibility, basically, of the requisite technology, and there's no carve-out for electrification. And I just want to step back for a second, that the whole point of 7521A is for EPA to protect the public by reducing motor vehicle emissions by using technology. So it would be really perverse to require EPA to ignore electrification, which is not only a very effective technology, but also one that's embraced by automakers. I do want to address the question about the standards applying to EVs, because I agree that is important to the outcome. So the regulatory scheme revolves around motor vehicles, and 7550 defines motor vehicles again functionally, not based on emission level. It says any self-propelled vehicle designed for transport on public roads, and that includes EVs. So then you look at 7521A, which applies the standards to emissions from any class or classes of new motor vehicles. And by using the words class and classes, Congress is identifying the harmful emission as a problem that occurs at the class level rather than the individual vehicle level. And so the standards apply to the class. And if you keep reading A1, the last sentence actually says that. It says such standards shall be applicable to such vehicles, meaning motor vehicles, whether these vehicles are designed as complete systems or incorporate devices to prevent or control such pollution. So this last sentence is saying that the standards apply to motor vehicles with devices that prevent pollution, which perfectly describes EVs.
Could you repeat which statute that was?
I'm sorry, this is 7521A1. Last sentence. So this is still the language about emission standards applying to emissions from any pollution, from any class or classes. It's just the last sentence of that provision. And our reading is in line with the regulatory scheme, which is to reduce emissions by putting controls on these motor vehicles, right? Because both EVs and internal combustion vehicles are motor vehicles with emission controls on them. Electrification is a lot more effective, but that's not a reason to disqualify them
or motor vehicles with that technology from the effort to reduce motor vehicle emissions. And in fact, to exclude EVs from the standards would deprive automakers of a really effective and a cheaper way to comply. It would also create this absurd outcome where automakers would be able to use emission controls that are 99% effective, but not 100% effective, which is, again, contrary to Congress's goal with 7521A. And of course, automakers who produce the EVs are not here complaining about their product being regulated. And I do want to note that the Auto Alliance interveners, they actually represent automakers who produce something like 95% of new motor vehicles in the United States, and not just a few petitioners suggested.
Let me make sure my colleagues don't have additional questions for you this time.
I'm interested in the zone of interest.
Sure. And if I could also get a word in about the time bar. So the zone of interest excludes parties more likely to frustrate than further the statutory objective. And here, 7521A's objective is to use technology to reduce emissions while giving due regard to the burden on automakers. Petitioners want EPA to ignore electrification, and that would impede EPA's efforts to regulate emissions and automakers' ability to comply with the emission standards. As for the Energy Future Coalition, that is a fuel case, not a case dealing with standards as such. And as Delta Construction explained, the breadth of the zone of interest varies by the provision at issue.
You wanted to make a word about timeliness?
Sure, yes, the time bar. As we said, the disputed parts of EPA's program for greenhouse gas standards were established in 2010. Petitioners missed their jurisdictional 6-day deadline, and because their opening briefs don't argue that EPA reopened the 2010 rule, either actually or constructively, they have forfeited that argument. And then on top of that, they have, in effect, conceded our forfeiture argument by not disputing it in the reply.
Okay. All right. Thank you, counsel.
Thank you.
We'll hear from Respondent Intervenors Counsel now. Mr. Donahue.
Chief Judge Srinivasan, and may it please the court.
You might need to put the mic up or the
If
podium.
you want to hear me. How's that?
Good.
Better? So on exhaustion, I mean, we submit there's just a complete failure to exhaust any of the arguments, statutory, factual arguments about the grid. The Clean Air Act 7607 D7B is quite explicit, as this court has said. It enforces it strictly for good reason. And these arguments were not raised. The reply brief does its best to point to comments, and none of them comes close. There's no mention of averaging, for example. And I would cite a case on key assumptions, the Utility Air Regulatory Group case 744 F3rd 748 note 4, where the court kind of said there's been a more basic failure to identify like the key assumption of what. There was no comment that said you can't do averaging in the context of greenhouse gases, but then failed to elaborate. There's nothing. There's a total void. My clients have to comply with this provision. It's important. It's not just a kind of empty formality. And this argument shows why it's important, because there's been a lot of argument about what is the actual impact of this rule, how far does it go in creating incentives or going further with electrification, and all kinds of arguments. It's been treated as somehow established that there's some kind of statutory bar against some kind of electrification, which I think is totally wrong. But one reason that we're less sort of up to speed than we would be is that none of this stuff was raised before the agency. The next time EPA sets standards, as Mr. Wall suggested, I am sure that people will raise these arguments with great detail, but it's really not not proper, not fair to other parties, to the agency or to the court itself to go ahead and grapple with things this important that were not raised at all.
Can I just stop for a second? I think I heard you say statutory bar against electrification. I just want to make sure. You mean statutory mandate for electrification?
No, I'm saying, they say there's something in the statute that says
Oh, I
EPA
see.
has to somehow exclude one technology that is sub silentio, even though it's the most effective. And that leads to the next point I'd like to make. We've used the term electrification a lot, and of course, that's like a spectrum from power steering, which does reduce pollution, and things like stop-start technology, those little batteries that turn off the car at a stoplight and then start it back up again, to hybrids, various kinds of hybrids, including plug-in hybrids that can operate on the battery all the time if you plug them in enough, and then to battery electric vehicles. And so just one point I'd make about that is, first of all, it's important to try to figure out what the petitioners are saying about where the line is. I don't take them to say EPA can't rely on power steering or hybrids or even perhaps plug-in hybrids. It's got to use gas, apparently. That's their rule. But it's a sort of an odd rule that has no basis, we think, in the statute.
I thought part of what they're saying is that one group that you can consider together is every group that the agency itself says we should treat as zero emitters. And that would include hybrids.
Right.
Even though in theory, the agency could have done something different with hybrids, but they didn't.
Well, this is the class argument. I think there's if I'm understanding the court's question, the statute says any class or classes, so it's language that suggests some discretion for the agency. The agency has never created a special class for any particular sort of subcategory of emission-reducing technologies, including electric vehicles. And we think that grammatically, and again, this is all unexhausted statutory speculation that the agency hasn't had a chance to fully elaborate on, but the far better reading is that EPA has it right, that you can include non-emitting vehicles. And I think the text of section 7521A, that second sentence of A1 that talks about preventing and controlling pollution, preventing pollution. We think the natural reading is, and this is a Clean Air Act theme, prevention. The Clean Air Act says where you can actually prevent pollution instead of having to struggle with capturing it and then storing it. That's better. That's in the very first section of the Clean Air Act. 7401C talks about that as directing the federal government to focus on prevention where it can. So the idea that EPA has to exclude these clean cars from the categories is just a stretch. And then, of course, there's the fact that Congress did define motor vehicle in a way that is agnostic as between what powers the vehicle, which seems quite significant.
And is there another statutory provision that allows the EPA to include EVs in the class? I'm looking at 42 USC 7521A3A2, which says that the EPA may designate classes based on gross vehicle weight, horsepower, type of fuel used, or other appropriate factors.
Yeah, I mean, I think that attests to the fact that Congress was okay with the EPA using these functional categories. That's what the definition of motor vehicle itself is. Note, as EPA's brief points out, there's another provision that talks about, I think it's a heavy-duty vehicles provision that does identify, does talk about internal combustion engine. So it's like stands in contrast to this one. So I think that when that issue is properly preserved, that EPA should and will win it. But it really, precisely because it's important, it seems like a total failure to raise it before the agency is not excusable here. I mean, it seems like at a common sense level, if it's really a major question, somebody would have pointed it out, right? If major questions, as it seems to, involves a certain amount of, we know it when we see it, the fact that nobody raised this in the very extensive public comment period was is significant.
But I think part of their argument is that it's so major and it's such a fundamental presupposition that actually the exhaustion principles don't matter because it becomes the keyest of key assumptions.
Right. And I think, first of all, I think I would point to that. You are like, it might not matter that nobody cited, major questions in terms or cited Brown and Williamson or any of the particular cases, but there was just no one said, apparently, no one's been able to identify anyone who said you can consider electric vehicles and you can consider hybrids. Presumably, they don't seem to say that hybrids are statutorily verboten. But once you go from a plug-in hybrid that's like mostly battery in practice to a fully battery electric vehicle, all of a sudden it becomes illegal. Nobody said that, and it doesn't require sort of parsing and a bad faith reading of anyone's comments to get there. It's just there's a void. I'd also just like to certainly agree with Ms. Chen about West Virginia. This is not like West Virginia. This is about making the regulated sources cleaner, which is what West Virginia says EPA can do. And this is EPA using the exact same methodology that it has used since the Clean Air Act was enacted 50 plus years ago, of assaying the technologies that are out there, determining which ones are feasible, cost effective, and then basing standards on a realistic assumption of what. And note that this isn't even pushing to the limit of EPA's power, as this court has recognized in a lot of the early cases under Clean Air Act Title II, which is technology forcing, which is where EPA says the technology isn't really quite ready right now, but we really need the public health benefits, and we think that we can get there. The sort of direction of study is such that these are all off the shelf. These are all on the road now, the technologies that this rule is based on. And that's doubtless why, coupled with the fact that they think that this is where their business is going, the Alliance, which represents basically all auto manufacturers that sell in the United States, is supporting this rule and saying things like, on page 3 of their brief, the auto industry is already rapidly deploying electric vehicles in their US sales fleet, even apart from the final rule. And there's nothing, this is page 6, there's nothing unprecedented about EPA's use of fleet-wide averaging, banking, and trading under Section 202, nor in setting standards that require greater deployment of emission-reducing technologies such as electric vehicles. I think it's the idea that the agency is overstepping is in significant tension with the fact that the industry itself is saying it's going to go faster than the agency is even requiring. Thank you very much.
My colleagues don't have questions for you. Thank you, counsel. Mr. Wall, we'll start with 5 minutes for rebuttal.
Your Honors, I have to say I'm fairly floored. I've been litigating this case for a year on the belief that we were in mandate land, and I got that from the rule because it says at page 5 of the JA, their standards are achievable. I'm reading at the bottom of the middle column on JA 5. It says they're achievable primarily, not only, primarily through the application of advanced gasoline vehicle technologies, because of course there'll still be 83% potentially gas vehicles in the fleet, but with a growing percentage of electric vehicles. We project that the standards can be met with gradually increasing sales from 7% to 17% of EVs. In their brief, they had every opportunity to come back and say, this is not about forced electrification. We are not mandating a transition. You can do this only by improving the efficiency of gasoline-powered vehicles. There's not one word in their brief about that. The automaker's brief.
Go ahead.
I was just going to say, if Mr. Donahue had read just the next sentence in the automaker's brief, it is true that EPA's new standards will require greater deployment of electric vehicles by full-line vehicle manufacturers. And I understand the government to now turn to Subaru. Judge Band, there's not a word in their brief about it. The Subaru comment letter is not even in the JA in this case. They have never tried to say, no one on that side of the V in all of the briefs in this case has tried to say, no, this is still an option. It's just a matter of cost. You can improve your gas-powered vehicles and you can still manage to meet the standard. The rule says you can achieve it primarily through improving gas engines, but it can be met, it says, by ramping up sales of EVs. That has always been, if the government now.
I don't even understand that statement, though, to do the work that you're reading into it.
Oh,
Because it doesn't say can only. It says it can be met. And of course it can be met. I mean, nobody denies that the projected percentage is going to go up. The question is whether the percentage goes from 7 to 17, because that's the only way practically to comply.
Chief Judge Srinivasan, that is the way I understand this and the way I have always understood the other side not to fight is that they put so many zeros in the standards for EVs that the only way to comply with the standards they've set is to either make more EVs or to buy credits from companies like Tesla that manufacture EVs. If the government's position is now that the primarily should be an only, that it's achievable through the application of advanced gasoline vehicle technologies alone. Now, you can also choose to sell more EVs, but you don't have to. That'd be the first time the government's ever said that, and frankly, I'd like to see it in writing. I don't think the evidence in the record could support that proposition.
I hear their position to be that they're allowed to require some electrification because it's technologically feasible. They're just setting an emission standard, and is it technologically feasible? And one of the aspects of that is electrification. And it seems that there's nothing in the statute, and you can correct me if I'm wrong, that says you can't consider electrification and even some mandatory electrification. We'd be maybe in a different world if we had Judge Katsas's hypothetical where zero emissions, 100% electrification is required. But if we're just requiring, I guess my hypothetical to the state's attorney, maybe it requires 1% or 2% electrification. What's wrong with that?
Oh, Judge Pan, I think the government's also making that argument. I understood the government to be making both arguments this morning. And the first argument is not supported by the record and does not appear in their briefs. Now, the second argument, I absolutely grant they are saying, we can require some electrification if it's technologically feasible. Now, first, I think that's clearly a major question, and the government is quite candid about
So
saying.
even 1% electrification would be a major question
If you
in your
force
view?
electrification, doesn't matter what the percentage was in West Virginia, if you force electrification, that's a major
So
question.
you think they have to avoid mandatory electrification? They have to set a standard that is not going to rely in any way, shape, or form on mandatory.
Oh, I don't think that's what the act says. So in 202A1, it says, the administrator can set standards applicable to the emission of any air pollutant from any class or classes of new motor vehicles or new motor vehicle engines, which in his judgment cause or contribute to air pollution. And the debate here between the parties is, do only some vehicles in the class have to cause or contribute to air pollution in the EPA's view? Or is the class defined by that and all of them do? And I take even the government to acknowledge that if we're right about our statutory interpretation, they cannot feed EVs into the standard and set the standard by considering EVs. And that's what's so odd about this case.
So your position, I just want to make sure I'm understanding you, is that the EPA, in setting emission standards to protect public health, cannot consider electric vehicles in the mix of classes of automobiles that are being regulated.
If it says that those vehicles do not emit the relevant pollutant. So it didn't say that for hybrids. It said for strong and mild hybrids, those are burning gas, so they do, and it put them in the class. And we haven't challenged that here. But for the vehicles.
I'm just trying to get the big picture of your argument. You're saying EPA cannot consider electric vehicles in regulating classes of vehicles. They can't regulate electric vehicles. They can only regulate combustion engine vehicles.
If they say that the EVs do not emit the relevant pollutant, they are not eligible to be included in the class for which the administrator sets a standard.
But what about the
That's absolutely right.
definition of motor vehicle, which doesn't exclude EVs, and these other statutory provisions that say that classes can be defined by things like weight of the vehicle?
Oh, look, the definition of motor vehicle, like I agree, that's not doing any work here. That's broad enough to cover any vehicle. What's doing the work is that it tells you you have to have a class of cars or engines that emits the relevant pollutant. You get that class, and you can set a standard for the class.
So
And then,
does your argument then reduce to interpretation of class or classes of vehicle and an insistence that it must invariably be read to exclude electric vehicles?
on our second argument, on whether you can force electrification, I take it both parties, that's the argument, 202A1, and how to read that class's language. They say it's clear in their favor. We say not clear enough to be a major question, and even if you don't buy that overlay, we're right about the most natural meaning. I think everybody agrees that's the question, the second question. And then the first one is, can they average at all? And no, that doesn't depend on 202. 202A. That depends on other provisions in 202 and in Title II more generally that indicate that what Congress had in mind was you set these standards and then you determine whether individual vehicles comply.
Doesn't that
Nothing
really
about
hamstring
averaging.
the agency? It's been given a task by Congress to set emissions levels to protect public health, and you're telling them they have to ignore the most effective technology to set these standards at a level that they do have to be technologically feasible and have economic considerations. But you're hamstringing them, aren't you, by saying that they cannot consider electric vehicles?
Judge Van, I'm not. Congress is, and the last time it looked at this most closely with respect to the second case you'll hear this morning, it said to NHTSA, unlike here, you can fleet-wide average, but you can't consider electric vehicles.
So
And the
every
same
time,
argument,
I'm sorry, but every time they've applied this exact same statute before, they have not read it this way, and it hasn't been challenged.
they have averaged and they have allowed electrification as a compliance flexibility.
And the classes of vehicles included electric vehicles.
They have folded them in, that's right, but only in a way that was a compliance flexibility. You could meet it other ways. And what's new about this, and what squarely tees up the major question doctrine is, they've now
Right,
asserted.
but apart from major questions, I mean, you can shift to major questions, but in terms of the underlying statutory authority, you'd have the same problem with what happened before.
Yes, I have a problem both with averaging and with folding in the EVs, but the reason I think it's sort of different for all of the threshold purposes we were talking about earlier and major questions is, before it was meant to be a shield for the industry, and now they've gone to a sword. It is now something that forces the kind of transition that you saw in West Virginia. And
So there's obviously a disagreement on that. And on that, you say that you're stunned because you've always understood the case to be different. I'm just looking for something in the written record that tells me that they viewed the case as you thought they viewed the case.
So-
And is that the statement that you identified?
I mean-
Is that the best one? Because even in the brief, I mean, I don't think they ever, as far as I know, in the brief, they don't actually agree with your characterization.
I think it's a little bit like the dog that didn't bark, I guess, Your Honor, which is in the rule, I take all this language. Now, I'll grant that like it's very carefully phrased, but I take all of this language, the most natural meaning to be, my understanding from my clients, and the automakers say at page 6 of their brief, they are required to make more EVs or buy credits. That's the only way they can satisfy the standard. And I read the rule that way. I didn't take the other side to dispute it. And the first time I've heard anybody say, no, you don't have to make more EVs or buy credits to meet our standard, was here in court this morning. And it seems
But
to me.
I think even the word require, it depends on, it could mean that we're required to do it because that's by far the most cost-effective way to do it. But we're essentially required to do it. It just begs the question of what are we baking into the concept of being required, just like the $1 less in costs that we had a debate about that. And so I don't know that question has ever been actually joined and addressed in any of the materials.
I mean, we joined it in our opening brief by saying you're forcing electrification. The time for them to say that wasn't true was in the red brief. But I look at the rule, and I don't think that's the right reading that you're giving to it, Judge Srinivasan. When it says primarily achievable, but with a growing percentage, we predict the standards can be, we project that the standards can be met with gradually increasing sales. The most natural meaning of that is that's the only way you can satisfy the standard. Not, I mean, if they wanted to say it's achievable, not primarily just achievable with gasoline technologies, they could have said it in the rule. I mean, this rule was more aggressive because of all the options they were considering, right? The president issues the EO, and then they come out with a more aggressive rule than anything the EPA had been considering before. They say in the rule, I think this is page 51, that it drives electrification. They say at page 60 that it necessitates greater deployment of technologies, including EVs. I mean, at every point, the most natural reading of the language is the one we've given it. And I would have thought that if anyone ever disagreed with that, they would have put it in the brief.
So the table that has Subaru at 0 is also in the rule, right?
Right.
It's in there. So, I mean, I think the statements, can be judged against the empirical stuff that's laid out in the rule, one of which is a 0. At least you would agree that if your interpretation of the bottom of the middle column of JA5 to the top of the right column of JA5 is right. That's incompatible with what the rule itself says about Subaru in the table.
Oh, so I haven't studied Subaru enough in the table to know, and obviously the government never pointed to that.
Yeah.
No one, so I can't stand here and tell you that I know anything about Subaru, which is not in
But
the
in terms of the
application.
representation that it's going to be at zero, that just couldn't be possible. No manufacturer can be at zero.
I'm not sure exactly what the agency meant by that, and I don't know how they ran the numbers for Subaru. All I can tell you is, if I have always understood that to be their position, and I didn't understand them to dispute it until today. I think as the case comes to the court, it should take it that way. If the court thinks that there's now some open question about that, then I think the parties ought to have a chance to address it, because I'd like to see the evidence in the rule, not outside the rule, but in the rule for chenery purposes, that the agency can point to say, no, you don't need to electrify in order to meet this. I have read, I've been over the rule multiple times. I don't see anything like that in there. But at the end of the day, for major questions purposes, the government quite candidly says we can move to 100% and it's not a major question. All respect, I disagree. You turn to the text. I think it clearly says you can't include EVs in the class and you can't average. But again, I don't need to be right about that. All the court has to say is 202A1 is not clear that you can set standards with respect to EVs. If you want to do what you were doing with averaging and compliance flexibilities, fair enough. But when you move to a mandate, you've gone further than Congress would allow. That's a decision for Congress unless it clearly vested in the agency. That's the way that we think the court should resolve the case.
What do you do with the clause at the end of A1, which says that the vehicles or engines that are subject to regulation include systems that incorporate devices designed to prevent or control pollution? If you contrast prevent with control, seems like that's saying control means drive down, prevent means drive down to zero. That tends to suggest that zero emitters can be in the relevant class.
Okay, so I should have addressed that, Judge Katsas. I appreciate the question. The first thing to note is that the second sentence is doing different work from the first. The first tells you the class for the
Second in A1?
In A1, exactly. So it tells you how long the standards apply. It says the standards apply for the useful life of the vehicle, and subsection D defines the useful life. And so it says the standards that are set under the first sentence, they're in effect for the useful life of the vehicle, regardless of how the vehicle is designed or manufactured. So the second sentence isn't expanding the class in the first sentence. It's just telling you how long the regulations last. And then the second thing I'd say is, when we say, Judge Katsas, vehicles and engines designed as complete systems or incorporate devices to prevent or control such pollution, that is a perfectly natural way to talk about traditional vehicles that burn liquid fuel and produce emissions. It is not at all a natural way to talk about EVs. If I said that my iPod is designed as a complete system to prevent or control record skips, you'd say, like, no, it's just a different kind of technology. And it feels like we're having the West Virginia debate all over again. It's not that you can't come up with some literal hyper-technical reading of best system of emission reduction that just says, that's a renewable fuel-powered plant. But it is not the most natural reading of system or prevent or control pollution in the context of this provision.
I'm sorry, you're saying this language doesn't include electric vehicles, engines that are designed or incorporate devices to prevent or control pollution? That doesn't apply to electric vehicles? That's
Exactly what we're saying, Judge Pan, as we said in our brief. That's dealing with traditional vehicles and trying to design them to run cleaner and emit less. And they want to say,
I'm sorry, but why doesn't that apply to electric vehicles? It just seems on its face that it would.
I just don't think that's naturally the way we talk about something that doesn't emit the pollutant in the first place. This is really natural language for Congress to use when it wants to talk about vehicles that emit the relevant pollutant but are designed in some way to try to prevent or control or capture it. And we know because it's following the first sentence, and the first sentence is talking about classes that emit the relevant pollutant. So what Congress has in mind are polluting vehicles. When they come in and say,
I'm sorry, but you don't think an EV was designed to prevent pollution?
I don't think no, that is what I mean. The text of this provision in context, setting, if you set aside my first argument to Judge Katsas, which is this doesn't expand the relevant class at all, but if you set that aside, no, in context, it follows a sentence that talks about setting standards for vehicles that emit pollutants. And then it says standards apply for the useful life regardless of how they are designed to prevent or control that pollution. It is not meant to capture vehicles that, in the EPA's view, don't trigger the first sentence at all, don't emit the relevant pollutant. I'm not denying that just as in West Virginia, you can look at the words and try to give them some literal reading, but that is not the most natural meaning in context.
So do you read prevent not to mean prevent altogether?
Well, I read it to mean the devices or the systems that are incorporated into the vehicle are preventing the pollution, which is to say it's a vehicle that would otherwise be producing the pollutant absent that system. And here, what they have are just vehicles that they say don't emit the relevant pollutant in the first place.
So I guess it would be odd to speak of a bicycle as a vehicle that prevents or controls pollution. Is that-
I find it very weird, but I think on their view, they would have to say that they could put bicycles in the class because they can put things in that don't emit pollutants.
Well, I mean, they're not motor vehicles, so this
Yeah,
is just a linguistic point, not a.
If you
regulatory.
had a motorized bike, right? I think they would say that could fall within both sentences. And now at that point, they might be willing to say, that's a major question because now you've gotten into modes of transportation as opposed to motor vehicles. And I would say, look, that's not a distinction from West Virginia. West Virginia was factories. Here it's motor vehicles. You can make the factories run cleaner. You can't make them switch power sources. I can put in cars for factories, and the sentences I just said are equally true.
Okay, thank you, counsel. Thank you to all counsel. We'll take this case under submission, and we'll take a brief recess before we switch to the next case.
This honorable court is in session again. Be seated, please.
Okay, I guess are we ready to transition to the second case? Thank you, counsel. Mr. Arthur, please proceed when you're ready.
Chief Judge Srinivasan, and may it please the court. This case involves another prong in the administration's strategy to outflank Congress on a major policy question by forcing electrification of the nation's vehicles. In this case, however, agency's path is blocked not just by the lack of clear congressional authorization, but by an express statutory prohibition. Section 32902H is crystal clear that in setting fuel economy standards, NHTSA may not consider the fuel economy of dedicated automobiles like electric vehicles. It shall consider dual-fueled vehicles like plug-in hybrids to be operated only on gasoline or diesel fuel, and it may not consider the availability of compliance credits. Congress enacted subsection H because it intended alternative fuel vehicles and credits to be compliance flexibilities. It recognized that if NHTSA could take them into account in setting the standards, they would become effectively mandatory. In other words, Congress wanted to encourage production of alternative fuel vehicles by creating an incentive to produce them, but it was not willing to mandate them by allowing NHTSA to set standards that can only be met with the fleet that includes alternative fuel vehicles. But that is precisely what NHTSA did in this rulemaking. In its zeal to facilitate a transition to an all-electric fleet, a goal that Congress never authorized the agency to pursue, NHTSA violated all three prongs of subsection H. And as a result, it set standards that cannot be met by a fleet of conventional gas-powered vehicles as Congress required. I will begin with and focus primarily on the first prong of subsection H, which in categorical terms forbids the agency to consider the fuel economy of electric vehicles.
So can I just ask you, as you begin, everything you've said and you're about to say would equally be true of the rule that would come into place if you got the relief you seek?
That is not true, Chief Judge.
Okay.
The only electric vehicles that were included in baseline in the prior 2020 rule were the ones that were in what the government calls the pre-existing fleet. That was in the prior rule, the 2017 fleet. And at that point, it was only 0.6% of the vehicles that were in the fleet were electric vehicles. But NHTSA went well beyond including.
No, but as to that, under your view, even that was wrong.
Yes, that was unlawful for them to do that. That's correct.
So it is equally true. In other words, the prior rule that would now come into place would be equally invalid, given the arguments you're making now.
I don't know that I would go so far to say invalid. I think it was unlawful for the agency in 2020 to include the baseline, the 2017
Yeah, I meant
baseline.
invalid in
Whether-
terms of invalid under the law.
Yes, whether that made a difference to the standards that were set in that rulemaking, I don't know. I would not be surprised to find out that only 0.6% of the vehicles in the fleet didn't in fact make a difference to the level at which the standards were set back in 2020.
But equally unlawful.
Yes, equally unlawful. So
Is there something that seems odd about that everybody has assumed, including a rule that kind of pointed in the opposite direction in the eyes of some, that at least taking into account electrical vehicles in fashioning the baseline was okay.
So it doesn't strike me as odd, Judge Srinivasan, because it was such a small percentage. I don't think
Okay.
the parties were focused on that issue in the way they became focused on it in this rulemaking, because NHTSA went well beyond the baseline fleet. And the baseline fleet here included 2% electric vehicles, much more than 0.6. But they also went beyond the pre-existing fleet and included 2 additional categories of electric vehicles in this rule. First, they also included in the baseline the electric vehicles that the agency projected would be added to the fleets to comply with the state zero-emission vehicle mandates. And NHTSA even considered in this rulemaking the electric vehicles that it projected would be produced in response to these very standards, the amended standards being set in this rulemaking, as long as the electric vehicles were added outside model years 2024 to 2026. So you have additional categories of electric vehicles being added that bring the percentage way above where it was in the 2020 rule. And so it's not surprising in this rulemaking that parties focused on subsection H. And when you look at subsection H, it's very clear that it draws no distinction between whether it's a pre-existing vehicle or one that you're projecting is going to be produced in response to a state mandate. There's nothing in subsection H that allows you to treat those 2 kinds of electric vehicles differently.
So
Statute says,
Can we focus on the baseline for a minute? Because
Sure.
isn't one way of looking at the baseline is that it's just an objective thing. It just is what the world is without the regulation. And it doesn't seem to be something that's subject to policy concerns or mucking around with it. It just seems to be an objective thing. And in terms of amending the regulation, what the agency seems to do is it amends the regulation and it compares it to the baseline, but it doesn't have to. It could just set a regulation without comparing it to a baseline. It just doesn't seem like the baseline is number one, something other than objective, and number 2, subject to this carrying out rulemaking. It's just something you compare to the amended rule.
so Judge Penn, I don't think the baseline is quite as objective as Your Honor is making it out to be, because it is still a projection. What NHTSA is doing is saying, we're looking at the electric vehicles that were in the 2020 fleet, and we project that you will continue to make those electric vehicles in 2024. And so in some respect, they are not just reflecting reality, they are constructing it. They're saying, because you made them then, we are now going to set our standards at such a level of stringency that you will be required to continue producing.
Well, it's an assumption that they're making in setting a baseline. But the idea of the baseline is this is what the world looks like absent the amended regulation.
That is the idea of the baseline. And
It
Your
just
Honor,
seems like an objective concept to me.
well, whether it's objective or not, the question is the agency considering the fuel economy of electric vehicles when it includes them in the baseline? And it seems to me it necessarily is. As the agency itself explained, this is on page...
Well, there are electric vehicles in the baseline because the real world has electric vehicles, and in the real world, they will continue to make more electric vehicles in response to things that are not related to the rulemaking. Just seems to me analytically different from carrying out C, G, and F
Well-
to have a baseline. The baseline is just what you compare it to.
So a couple of points, Your Honor. There's no dispute that subsection H requires the agency to ignore aspects of reality. That's true on this interpretation. It's true on ours as well. It's just a question of to what extent are you ignoring quote-unquote reality. But as to the question of whether you are carrying out subsection F when you construct an analytical baseline that includes electric vehicles, it seems to me that you absolutely clearly are. As NHTSA itself explained, it's 973 of the Joint Appendix. They said, we use electrification technologies assigned in the baseline fleet as the starting point for regulatory analysis. And it's-
Correct, but F is forward-looking, right? It talks about considerations in the decision, and it lists things that seem to be forward-looking. Feasibility, practicability, and it seems to be, there is going to be some kind of a baseline assumption, but in terms of applying F, that's a forward-looking application.
I agree that it's forward-looking, and what it is asking the agency to do is to assess, among other factors, technological feasibility and economic practicability. And NHTSA does that through its model. It models a fleet to determine whether or not the standards are technologically feasible and economically practical. And when you put electric vehicles in that fleet, that necessarily means that NHTSA is considering their fuel economy as it considers technological feasibility and economic practicability, because the electric vehicles in the baseline are not just there at the start. They are there at the end as well. They are carried forward into the fleet that NHTSA models to assess whether the standards are technologically feasible and economically practical. In fact, if your honors wanted to see a picture,
Must have been quite a dramatic point you just made.
I said, I'm about to get even more dramatic. If you want to see a picture of what it looks like to violate subsection H, you could do no better than table 536 on page 1087 of the joint appendix. What that table shows is that in every one of the regulatory alternatives that NHTSA considered in this rulemaking, electric vehicles comprised at least 4 to 5% of the fleet in model years 2023 through, or 2024 through 2026. And in the alternative that they selected as the standard, that's alternative 2.5, electric vehicles comprised 5 to 6% of the fleet in the standard setting years, rising to 7% by 2029. If NHTSA had complied with subsection H in this rulemaking, every number in that chart would be a 0, because NHTSA is not allowed to set standards based on an assumed penetration of electric vehicles. The statute says flatly, the agency may not consider the fuel economy of electric vehicles. They try to punch holes in that by reading in limitations that don't appear there. As I say, the statute says may not consider fuel economy of electric vehicles, full stop. What do they read that to mean? They read that to mean that they may not consider the new or additional electric vehicles that would be produced as a means of complying with the standards in the model years covered by the standards. Now, that is a whole lot of words that they have just added to the statute. And the government's brief repeats that formulation or variations on it more than a dozen times. But never once did they even try to explain how that formulation can be derived from or squared with the statutory text, because it cannot be. Those limitations do not appear in the text, and NHTSA is not free to read them in to suit its own sense of how the statute should operate. So,
Go ahead.
Is there any difference between how the statute operates for amendments versus regular standards promulgated in the first instance? With this cross-reference in H to C, F, and G is a bit of a head scratcher.
it is a bit of a head scratcher.
C and G are amendments.
Right.
And it might be a little bit simpler. Your argument might be a little simpler in the context of amendments, because the function carried out in C and G is amending. And you can't consider electric vehicles in carrying out the function of amending. That's very easy. And maybe the same logic applies to F, but maybe you're doing something in promulgating original standards that is outside of F.
So
I don't know.
there are a couple of things there, Justice, and I do agree that you don't even need to ask whether the agency considered the fuel economy of electric vehicles in carrying out F here, because there's no doubt that they were carrying out subsection G and probably subsection C as well, because they were amending the standard. But here's how I make sense of why it's C, F, and G and not the other.
Right.
When you are setting a standard, you're governed by F. Whether it's a new standard or an amended standard, if the statutory language says you have to set it at the maximum feasible level, you are governed by F. You are also doing an additional thing when you invoke subsection C or G. You are making a discretionary decision to amend the standards in the first instance. And so I think that's why you see Congress adding C and G to subsection H, which is to make clear that even in that threshold step of making the discretionary decision of whether to amend an existing standard, they can't consider the fuel economy of electric
I
vehicles.
had thought the amendment case might be a little bit simpler because if we're under F, we're at least facing a question about whether these factors are exclusive. It says the agency must consider those 4 factors. It doesn't say it may not consider anything else, and could electric vehicles bear on some other consideration? Maybe yes, maybe no, but I had thought you don't get into any of that under C and G. But your formulation equates the two. If C and G are just about the discretionary decision whether or not to amend at all,
No, I
then
think C and G
we
are
might
about,
have the same question regardless.
I think C and G, Judge Katsas, are about both. But I don't think C and G takes you outside of F. I think when you are amending a standard under C or G, you are subject to that maximum feasible standard, and F tells you when.
And when you've made the discretionary decision to amend and then you're fixing the standard, you're still carrying out the function of C and G.
I believe so,
Correct?
yes.
Okay.
And you are also, at that point, carrying.
And
out
you're also within
subsection
F, but, right, okay.
And
Is my understanding right, this is as a historical matter, that before the statute was amended to refer to C, F, and G, the way everything came together was that there was an H provision, but it only applied to amendments.
I have not looked at that, Chief Justice Srinivasan. I don't know the answer to that.
Okay.
Whether when H was originally enacted, you're saying it applied only to amendments?
I thought there was a time at which this prohibition, the limitations provision, which is what H is, only applied to amendments and didn't cover what's now in F and used to be in E.
I do not believe that is the case, but I can't warrant.
You think the way I'm
I
supposing is wrong?
thought the original version of H incorporated F, but I could be mistaken.
I see, incorporated new standards and not just amended standards.
Yes, incorporated any time the agency was carrying out the task of deciding what is the maximum feasible average fuel. That's my recollection, but again, I would not. warrant.
So what do you make of the fact that H excludes A and B, which is about setting standards?
I don't think Congress needed to include A and B because it would have been redundant, because the only thing the agency is doing under A and B is deciding the maximum feasible fuel economy.
But why
And
would,
F tells you how to do that.
but why would they bother to mention C, G, and F? They could just say, in carrying out this provision, you shall do these things.
Well, I think they, as I say, included C and G to make clear that they were also picking up that discretionary determination whether to amend a standard.
But wouldn't it be simpler just to say, when you apply this standard, we will not do these 3 things? It just seems very odd that they would specifically single out C, G, and F and not A and B
Well,
if they meant for it to apply to everything.
if what you mean by when you apply this standard, Judge Pan, if you're talking about this.
Carrying out, they say when you're carrying out C, G, and F. But they could have just said, when you're carrying out anything under this statute or this provision, you should not consider these 3 things.
Well, they may have picked up some things that they wouldn't have wanted to pick up if they had made it when you're carrying out the statute writ large. For example, if you look at subsection D, there is an option to give a manufacturer who doesn't think it can meet the standard a break. And there is a discretionary decision that the agency has to make there in deciding whether to give that manufacturer a break. And it would not be subject, in my understanding of subsection H, to this limitation.
Right, so they purposefully excluded D, but they also purposefully excluded A and B.
I don't think they purposely excluded all of D. D has 2 parts. D, you have to make a discretionary determination whether to give a manufacturer a break from the general standard. If the agency does do that, then it has to give that manufacturer a new standard that is the maximum feasible level that manufacturer can achieve. That would be subject to H.
So your friend on the other side would say that Congress specifically precluded A and B, which means that they didn't intend for this limitation to apply to every single stage of this process invariably. And I take your position to be very absolutist. Never, ever consider these 3 things.
Well, there are 2 parts to the analysis. 1, are you considering the fuel economy of the electric vehicle? And 2, are you doing it in carrying out one of the enumerated subsections?
Right.
One of the enumerated subsections is subsection F, which tells the agency how to decide what the maximum feasible average fuel economy is.
Yes.
So anytime they're deciding what is the maximum feasible average fuel economy, they're
Correct.
carrying out subsection
But-
F and the subject to H.
But I believe your position is anything they do in connection with F, including setting a baseline, is part of carrying out. And I think your friend on the other side thinks that because they've carved out things that are not subject to H, it doesn't invariably apply to every single step in the process.
It applies to every phase of what they do under F. That at a minimum.
But then the question is whether setting a baseline is carrying out, making an amendment. And it seems that if the statutory structure precludes some things, it lends support to the idea that not every single thing you do, including comparing to a baseline, must abide by H.
As a threshold matter, I don't think you have to decide anything about F here because they were undoubtedly carrying out C and G and everything they did. But even setting that aside, I agree that the question under F would be, are they carrying out subsection F when they construct the baseline? And I think the answer, for the reasons I explained previously, is undoubtedly they are. I don't understand even NHTSA to argue that its analytical baseline is not part and parcel of its determination of what standards are technologically feasible and economically practicable. Because as I say, where you start affects where you end. Maybe another way to come at this is to think about economic practicability. One of the factors the agency looks at in assessing economic practicability is what's going to be the vehicle price under the standard that we're setting. How much is that vehicle price going to increase? Well, how you think about that question is going to be very much influenced by what is the price of the vehicle in the baseline. A lower baseline price is going to yield a higher absolute and percentage price increase. And it may well be that if you have one baseline price, the standards are technologically feasible and economically practicable, and not if you have a lower baseline.
Is it
So-
possible theoretically to set an amended regulation without comparing it to a baseline?
Theoretically, I think that would be possible. I don't think you would have to look at a baseline, but I think that actually further reinforces my position because statute doesn't anywhere direct them to create a baseline, but it does direct them not to consider the fuel economy of electric vehicles. So I don't see how they can take the discretionary step of constructing a baseline out of, as part of what they're doing under subsection F and circumvent the statutory requirement. I don't have any problem with them constructing a baseline. That seems like a reasonable thing to do, but subsection F says if you are going to consider that baseline as part of your determination of what level of fuel economy is technologically feasible and economically practical, you have to exclude electric vehicles from your consideration.
In other words, if they had, if there was a thing that the agency did every year called a baseline report, and it was just for public information, and it incorporated electric vehicles because it's a fact about the world that those are part of the baseline, then you don't have any problem with that because it doesn't have anything to do with
Yeah,
the process we're doing here. But then if they use that annual report as part of the predicate against which they then constructed the next iteration of the mileage requirements, then you would think that runs afoul of the statute.
That's correct. If they are incorporating it in what they analyze and consider in setting the standards, then they're subject to H. If they're considering the fuel economy of electric vehicles for some other purpose, that's free and clear of subsection. For example, if they do an environmental impact statement to comply with NEPA, they can think about the fuel economy of electric vehicles when they do that, just as long as that doesn't enter into their standards.
So can I ask this question? And the very beginning of your argument, you talked about what Congress was trying to do here. And is it your view that the Congress that enacted these provisions, if they knew everything that we now know about the way these are going to play out, and let's just say that we're now at the point where the scenario that's mapped out by the government is in play, such that if you don't take into account electrical vehicles, we're at a point where there's really nothing that can be done anymore. If Congress knew that that's where we were headed, is it your view that they actually intended the result that you want? Or is it your view that actually Congress probably wasn't thinking about it, but that's just what the statute says, and so we give effect to the words and maybe take it one step further and say, and that result isn't antithetical to what Congress would have thought about, but they just didn't have this in mind, this scenario at all.
I don't know whether they had in mind this scenario at all, but I think my view is slightly different than either of those options.
Okay.
My view is they built flexibility into this law that can be used to address that situation. Not in subsection H. Subsection H is about as inflexible as statutory provisions come. The flexibility to address NHTSA's concern about obsolete fuel economy standards, increasing penetration of electric vehicles, appears in section 32904A2B of the statute. That is the provision that directs the Department of Energy to determine what fuel economy will be imputed to electric vehicles. Remember, electric vehicles don't have an actual real-world fuel economy because they don't burn fuel. So you have to assign them a number for purposes of this statute. Congress charged the Department of Energy with doing that. The Department of Energy comes up with a so-called petroleum equivalency factor to get an imputed fuel economy for electric vehicles. Adjusting that petroleum equivalency factor, as the Department of Energy is in the course of doing right now, for the first time since the year 2000, could eliminate, or
Do you
at
think it would
least,
eliminate it? I mean, we can ask the government that. I mean, I understand how it could do work to affect the disparity that the
I do
government
think
points
it
to,
could,
but you
I do
think
think it could eliminate it. If you brought the fuel economy of electric vehicles down from the stratosphere where it is currently now and made it roughly equivalent to the fuel economy achieved by conventional vehicles, I think NHTSA's hypothetical concern goes away. But at a minimum, they can substantially mitigate.
And then if they do that, we have a redo of the Texas case. There'd be a question about whether there's a major question to the justice scheme to force electrification.
Well, that doesn't seem to me that it would be forcing electrification. What would be
Well, if they
driving?
adjust the numbers, you know, Judge Srinivasan said the statute can only go so far if electrification is a compliance option, but not something you can consider on the front end.
Well, my
And you
point-
said, well, that's no problem. You can solve that problem by having DOE impute a different number.
You know, the problem that is solved by DOE of imputing a different number is NHTSA's concern that if you get fleets that are substantially electrified, NHTSA standards will become obsolete because every manufacturer will already meet them by virtue of the compliance boost they get from the EVs and won't have to make any changes to their conventional internal combustion engine. Number one, it's not clear that that's going to result as long as there are any manufacturers out there that do not substantially electrify if they continue to produce exclusively or substantially conventional vehicles. NHTSA standards will always remain relevant. So this hypothetical really only has bite in a world in which everyone has substantially electrified, and we're in a world where we say, but we would still like to see these standards drive further improvements to the fuel economy of the conventional fleet. And that's what bringing down the petroleum equivalency factor will do. It will not push, it will actually push away from electrification because it would decrease the incentive under this statute to produce electric vehicles.
So I don't understand how the petroleum equivalency factor would play into the analysis that NHTSA does in setting the standard. How would that work?
It shouldn't play into the analysis that NHTSA does in setting the standard on our view because
No, I understand, but you were saying that that would ameliorate the real-world problems with going with your view, and I'm having trouble following the train of logic.
so the train of logic is that the real world problem that NHTSA identifies trades on the enormous gap between the imputed fuel economy of electric vehicles and the actual fuel economy of conventional vehicles. When you get that huge compliance boost, that's what would allow manufacturers to say, we don't need to do anything to our conventional vehicles to comply with the standard.
In fact,
because-
not only do we not need to do anything, we could actually retrogress.
That's possible. But that's also possible under NHTSA's interpretation of the statute. So under either interpretation,
Yeah.
ours or theirs, automakers
Just
can
have more
avoid
occasion,
making,
you'd have more occasion under yours, but
I think that's probably right.
I stopped you going through the train of logic.
I think that was the train of logic. So the hypothetical that NHTSA has put forward trades on that enormous gap between the EV's imputed fuel economy and the real world fuel economy of conventional vehicles. You bring that down, it will no longer be the case that automakers can just say, because we've got electric vehicles, we automatically
Wait.
comply with the standards and don't.
So you're saying that with this imputed value, the fuel economy of electric vehicles will be lower?
Yes, what the Department of Energy has proposed to do right now is to bring that imputed fuel economy down by like 72%, where the electric vehicle imputed fuel economy will be about 1/4 of what it is today. And there are petitioners, or there are commenters, including my client AFPM, who are urging the agency to go even farther.
And so when, just to finish this, to make sure I understand. So then you're saying that when you determine whether any automaker is complying, you would be looking at the lower number, and therefore it wouldn't be.
They wouldn't get that huge compliance.
Okay, I understand.
That's exactly right.
And they can, the statute doesn't require that imputed number to bear any relation to the reality that the electric vehicles are really way more efficient?
So I see the statutory factors as pretty flexible and what DOE is required to consider. There are 4 of them. They look at the efficiency of the vehicle itself, look at the efficiency of the generation transmission facilities in the country. It's really the last 2 factors that I think DOE could sensibly look at to drive at the solution that I'm proposing here. Last 2 factors are the need to conserve energy and the patterns of use of electric vehicles compared to conventional vehicles. I think it would be perfectly lawful, sensible for the Department of Energy to take a look at those 2 factors and say, given this change fact about the world, that the patterns of use of electric vehicles have substantially changed. They have much higher market penetration than they did 20 years ago when we first looked at this. And we want to ensure that automakers still have an adequate incentive to conserve energy, that 3rd factor, continuing to improve the fuel economy of their conventional fleets. That would be perfectly rational, non-arbitrary for them to take those factors into account and pursue the policies of the statute that NHTSA itself is trumpeting here to continue improving the fuel economy of the conventional fleets and use that as a reason to bring down the fuel equivalency factor. I did want to address part of the government's reading of subsection F, because I think the closest that they come to a textual argument in this case is their contention that subsection H confines the agency only when it is deciding what increases over and above the existing fuel economy level are feasible. I don't think that is a tenable reading of either subsection H or subsection F. The words increase or improvement do not appear in either provision. That is notable because in this statute, Congress knew how to require increases when it wanted increases. If you look at subsection B2C of the statute, in that provision, Congress required NHTSA for model years 2011 to 2020, quote unquote, prescribe annual fuel economy standard increases that increase the applicable average fuel economy standard ratably, twice using the word increase. Similarly, subsection G2, Congress imposed a lead time requirement for amendments, but only when an amendment makes a standard more stringent. So Congress obviously contemplated that amended standards could be less stringent. There's no comparable language in subsection F. Subsection F does not command that every time they have a new round of fuel economy standards or an amended standard, that it has to be an improvement over the existing level of fuel economy. In fact, as we pointed out in our reply brief, in 1986, NHTSA decreased the fuel economy standards from 1987 to 88 by 1.5 miles per gallon in response to changed circumstances. In particular, the agency pointed to the fact that there had been a substantial shift in consumer demand toward larger vehicles as a result of lower gas prices. And it also pointed out that the technology on which the agency had originally relied in finding the standards to be feasible had not in practice yielded the anticipated fuel economy benefits. So standards can go down.
Make sure my colleagues don't have additional questions at this time. We'll give you some time for rebuttal. Thank you, Mr. MacArthur. Mr. Buschbacher.
Thank you, Chief Judge Srinivasan. May it please the court, Michael Buschbacher for the biofuels interveners. This case, like the other 2 that are being argued today and tomorrow, arises out of this administration's regulatory push to phase out and eliminate the internal combustion engine, replace it with the electric car. No law authorizes them to do this. No law authorizes any agency to do this, least of all NHTSA, which, as Mr. MacArthur has just covered, is statutorily forbidden from even considering electric vehicles when it's setting standards. We agree completely with that argument. What I'd like to focus on is this counter-argument that NHTSA makes in the final rule, where it says it just had to consider some electric vehicles because to otherwise would ignore the reality that California and other states have their own state electric vehicle mandate.
May I ask you a threshold question?
Yes.
There's an argument that the claims you're making were not raised by the petitioners, and absent extraordinary circumstances, interveners may join only on a matter that has been brought before the court by a petitioner. So there's an argument we shouldn't even consider your argument on the merits. Can you address that?
Yeah, happy to. So if you look at going to the initial statement of the issues that AFPM filed to their brief, pages, I believe, 43 and 44, they argue that these standards are preempted by EPCA. They go on to say that it was arbitrary and capricious for the agency to consider them. That, at the very least, gets us into the closely related standard that Judge Katsas nicely articulated in the Old Dominion Electric Co-op case. It's also logically antecedent to it. So NHTSA has this counter-argument, right, that we had to consider these electric vehicles because these state mandates are legal obligations forcing automakers to make electric cars. Well, if they're not legitimately forcing them to do that, which is our argument, then...
Well, does it have to be legitimate? Because that's a different question.
Well, maybe you don't have to, on this threshold question, whether you agree with me or not doesn't matter.
Right.
My point is that we're raising something that's logically antecedent. And again, I think it's closely related. It's covered in their brief. And like I said, it's in the initial statement of the issues. No one objected to our intervention when we raised this and we moved to intervene. But I don't think that is a impediment to us making these arguments. So let me address the EPCA preemption point. So it isn't reality, Judge Bannon and the rest of the panel, because those laws are preempted by a neighboring provision in EPCA, which says that states may not adopt or enforce a law or regulation related to fuel economy standards or average fuel economy standards. The relation between these state electric vehicle mandates and NHTSA standards is obvious. That's why NHTSA spent so much time talking about them and considering them here. NHTSA can't dodge this either by just saying, well, we don't really know about preemption, because that's just plainly not true. They do have a view on preemption. They discuss this on pages 1062 and 1146 of the Joint Appendix, where they find that these state laws are real legal obligations that states are free to enforce. That finding, and it is a finding, is contrary to law. And at the very least, it was arbitrary and capricious for the agency presented with these comments and these issues to just say, we're going to leave that for another day. That is black letter arbitrary and capriciousness under Little Sisters of the Poor.
What does the preemption argument get you above and beyond Mr. MacArthur's core point, right? We've been discussing whether the agency can consider electric vehicles as a fact about the world. And if the answer, for projecting, let's just say the 2020 baseline, right? If the answer to that question is no, your side has won the case. If the answer to that question is yes, they can consider electric vehicles as a fact about the world, it doesn't really matter how and why those vehicles came into the world. They're just there.
Well, so 2 points on that. One is that what they're trying to do here is get in through the back door, something that they're barred through from bringing in the front door. And we think that EPCA bars both the front and the back door here. So I agree, if they can't bring it in the front door at all, and this falls by the wayside, it's not a counter argument that carries the day on the considering point from EPCA. On the back door point, I think that the reality here has to be taken into account with the fact that these are vulnerable to challenge. I like the way that AFPM actually put it in their brief, to go back to the threshold point too, where they said that it put the rules in a tenuous position. It's something the agency just doesn't consider. It has a long-standing view going back to 2002 where it has treated these laws as being preempted by EPCA. And then it changes that, says we don't know, and now it says that they're legal obligations, but it never analyzes that factual reality. So even if they can consider it, it was arbitrary and capricious for them to do so without looking at the reality that these are subject to challenge and that they are indeed preempted by EPCA. And I think there's another point here, which is that there's kind of
I mean, suppose the challenge prevailed and California couldn't enforce this going forward. I mean, you wouldn't require these electric vehicles to be taken out of the world or destroyed or something, right?
No, I mean, so we're still not at the model years that are covered, right? So these are looking forward into the operation that this electric car mandate that California and these other Section 177 states have. And those have a forward, so if you actually look at the model years that they set the standards for, the only increases in the penetration of EVs, according to footnote 10 of the other side's brief, I think it's on page 54, the only increases off of the baseline that they use from 2020 are from these state electric car mandates. I'm not talking about taking anything out of reality. We're talking about adding new things into it. And they can't do that. At the very least, the agency can't just assume that these things are going to play out the way they do.
What's the standard under which you decide what are the things that the agency has to forecast? I mean, you said subject to challenge.
Yeah,
You
so
should never underestimate the ingenuity of interested parties and their lawyers. I mean, everything is subject to challenge.
I don't mean like it could be sued in court. What I mean is this is a substantial aspect of the problem. This is the Little Sisters of the Poor standard. What it says is when the agency knows about a legal issue, when it's been raised in litigation, when the agency's gotten comments on it, it has to give a reasoned explanation for it. So we think we clearly meet that. It's the agency's own longstanding interpretation that they've never refuted. It's the fact that it was raised in the comments and that it's been raised in litigation before. Put the agency well on notice that it had to look at this, and it can't just say, we're gonna just pretend that these are gonna have their full effect without even considering the possibility that they might not have the effect we're imputing to them.
So what should they have done? Should they have changed their baseline to assume that this would be preempted, or did they just have to explain why they were using the assumption that they did?
So I think they could have done a couple different things. One, they could have said, well, we don't know, so we're just not gonna put them in. That would, I think, have been reasonable, and they could have stayed with their view is, we don't have a view about EPCA preemption, we don't want to reach that in this rule. And if they did that, then they could have said, we're just not going to include them. Because getting into that would require...
But you think it's impermissible for them to assume that there wouldn't be a preemption? Because I guess at the time that they promulgated this, there was no challenge.
So if you look at the way that the timing was structured, they have their rule that repeals their interpretation, and then there's a 59-day window that you get to challenge that. That closes, I think, end of February, and then 9 days later or so, EPA puts the waiver back in place. So there was just never an opportunity.
But they must have some discretion to decide what assumptions they're going to.
Absolutely.
And I guess Judge Katsas' point is too that even regardless of the preemption issue, there was increased penetration of electrical vehicles historically, and they've been overperforming standards anyway. So why is it not within their discretion and reasonable to make this assumption that the world will be the way it is without preemption?
That's just not what they said, and it's not what they did. They do make all kinds of claims about how electrification is happening, but the only increases in the model years that are covered are the ones that are driven by these state electric car mandates. So that's what they're hanging their hat on, and that's what I think is a problem. If you're going to do that and say, this is the one thing we're so sure about, the reality we're so sure about, we're going to put it in.
But they don't have to be sure, right? They can just say, we're assuming that.
Yeah, they have still good reasons for that, and they don't even cross that threshold, right? My point is, my frontline argument is that there's really only one answer if you go down that road, and that these are preempted. But if they had just said, we're making some kind of prediction about, we think there's a 30% chance that these would go away, and so we're going to discount that by 30% or, amortize that in some way. But they don't do anything like that. There are a number of options that agencies have when it comes to giving a reasonable explanation. What Little Sisters of the Poor and the Regents case from the Supreme Court both say, they can't just entirely ignore it. And that's what they did here. They didn't even consider it. They just bracketed it off entirely and then made this unlawful finding that that states are free to enforce them. And that finding, I do think is contrary to law because states are not free to enforce them. The statute says states may not. And so that point is designed to bake this in a way that I think is really pernicious. It means that if we prevail in our challenges, at least the ghost of those standards lingers on here in the NHTSA standards, because they've been baked into this, into what they've put forward for the future. And that to me is a very serious problem. I've never seen an agency, I'm not aware of any case, the other side hasn't pointed to any case, where an agency has done something like that. And at the very least, they had to consider it.
Okay. Thank you, counsel.
Thank you.
Hear from the government now. Mr. Koppel.
I'm Josh Koppel for the United States. May it please the court. EPCA establishes an iterative process in which the Secretary establishes new fuel economy standards at least every 5 years that continually push automakers to do more to improve the fuel economy of their fleet. Section 32902A makes clear that each time the Secretary issues new standards, they're to be set at the maximum feasible average fuel economy level that the Secretary decides the manufacturers can achieve in that future model year, not at the level that manufacturers have achieved, but rather at the maximum fuel economy level that they can achieve in the future if required to do so. Certainly, the Secretary has to understand the current state of the fleet, however, in order to know whether the standards that he's setting will result in the production of a fleet that reflects the maximum average fuel economy level. And it's on the basis of the existing fleet that the Secretary determines what additional improvements manufacturers can achieve. To determine the maximum fuel economy level manufacturers can achieve, the Secretary is guided by the 4 factors identified in subsection F, including technological feasibility and economic practicability. And subsection H identifies factors the Secretary may not consider in that determination, including electric vehicles or the potential use of compliance credits. So subsection H ensures that the Secretary sets the standards at a level that can feasibly and practicably be achieved by manufacturers, making improvements only to the fuel economy of traditional vehicles. Although the statute also allows the manufacturers to achieve compliance by instead producing electric vehicles if they choose to do so.
So what you just said, the way you described the regime, seems like a totally coherent regime that could have been constructed. I think it's hard to dispute that proposition. But the question is whether it's consistent with what H says. And what's your best argument about the actual words of H that make what the scenario that you just outlined the best way to understand what the words say?
So I do want to get to H, but I think we have to understand H in the entire statutory context. And so I want to start actually with subsection A, which again directs the Secretary to set the fuel economy standard at the maximum feasible fuel economy level that manufacturers can achieve. So A is already making clear that the inquiry here is a forward-looking one. Subsection B3B makes this even clearer. It says that the Secretary has to revisit the standards at least every 5 years. So this is going to be an iterative process where each time the Secretary pushes manufacturers to improve their fuel economy and achieve and improve their fuel economy to the maximum feasible level. And subsection F identifies 4 factors, and each of those is forward-looking. It's not relevant to determining what the current fleet is. You don't consider technological feasibility when you compile just data on the existing fleet. You don't consider economic practicability. That's an objective question. The factors in subsection F are all forward-looking, and they're all directed at what additional improvements manufacturers can feasibly and practicably make. And then subsection H, which specifically constrains the Secretary's consideration of the subsection F factors. Similarly, those factors identified in subsection H then are forward-looking. And again, we know this because subsection F factors are all forward-looking, and in any event, under subsection A, the inquiry that the Secretary is to engage in is a forward-looking one. What is the maximum feasible fuel economy level that manufacturers can?
Then what are I mean, again, saying that it's forward-looking and that's the way that the world should exist seems totally coherent. But I'm just looking at the words of H, and where in the words of H doesn't say forward-looking. F, I mean, I think you could understand the factors in F to be primarily forward-looking. But if what I have to do is give effect to the words of H, what's the construction? What's the interpretation that the government is advancing of what the actual syllables that are in H? What's the interpretation that the government's advancing that's going to allow me to get to the result, the very coherent result that you think is the way the statute?
I think there's a couple ways the court could get to that result that I think that independently support NHTSA's approach here. First, subsection H specifically applies in carrying out subsections C, F, and G. And because the F factors are necessarily forward-looking, those are all directed at figuring out what additional technological improvements manufacturers can feasibly, practicably achieve. Therefore, H also only applies in conducting that forward-looking determination. Second,
And so what would you say that when it says in carrying out C, F, and G, what it means is in carrying out C, F, and G insofar as it's non-forward-looking? Is that what you mean? That's when you may not consider, I'm sorry, when it is forward-looking, you may not consider.
well, it's not adding a
Indicated on-
constraint when it's forward-looking. The factors in subsection F are inherently forward-looking. So, because subsection H only applies when the secretary carries out subsection F inquiry, therefore the subsection H constraints are also forward-looking.
What about C and G?
So C and G are added only to get at this preliminary decision that the secretary makes whether to amend the standards. It doesn't make any sense to think that the actual standard-setting process is different, whether the secretary is establishing standards for a particular model year for the first time or if he's amending them. The only difference is in that preliminary discretionary determination whether to amend the standards.
Why
And it-
not? It would be perfectly rational to have a system that is more constraining when the government establishes a standard and everyone plans to comply with it, and then they change those rules, than when 18 months out, they're just establishing a new standard for the first time.
A couple points. First of all, I don't think even petitioners argue that the standard-setting process is different if you're amending or if you are establishing for the first time, aside from this preliminary decision. Second,
No, that's right. You all, both sides of this case want us to decide this as an F question. I get that, but it's not clear to me that the amendment question is the same from the initial promulgation question.
yeah. Second, you raised this question about the lead time requirement, the 18-month lead time. That's going to apply even when the secretary amends under C and G if the secretary is raising the fuel economy level. So when the secretary amends the standard
That's
up,
true, except, agreed, but the initial promulgation will have caused the manufacturers to incur all sorts of costs designed to comply with that standard.
that may be, but once the secretary decides that he's going to go ahead and amend, he can certainly, again, take a clear-eyed, realistic picture of where he's starting from, what the existing fleet looks like. And what the statute is constraining is the ability to consider that manufacturers may comply by producing additional electric vehicles.
So on the textual basis for the forward-looking interpretation that you're advocating, the H says carrying out C, F, and G, and then the operative language in C and G is prescribing regulations, amending the standard, which is forward-looking. And F is considerations for decisions, which is forward-looking, because you're considering new decisions. So it seems that there is a textual basis on carrying out prescribing regulations or carrying out considerations on decisions that's all forward-looking. Do you agree?
Yes, I think that's right. And even leaving subsection F aside, right? Subsection G because when you're doing the amendment process, it just points back to subsection A, right, which confirms that the standard setting process, once the secretary has decided to go ahead and amend, the standard setting process is the same. And subsection A, again, itself makes clear that the determination that's the focus of the statute here is this forward-looking determination. What is the maximum feasible fuel economy level that manufacturers can achieve? There's no prohibition against the secretary starting from this objective baseline when he determines what additional improvements can be made.
Do you think that the way the petitioners are reading the statute is implausible?
I think that it certainly results in, it creates absurd results, and it imputes to Congress no limited foresight, I'd say. I mean, as the example in our brief demonstrates, at some point in the very near future, under petitioners' reading, the fuel economy standards lack all teeth. And they won't at that point mandate manufacturers to improve their fuel economy, even commensurate with their ability to improve the fuel economy of their gas-powered fleet. And the statute
What
here
about the
makes-
argument on that, by the way? I mean, I know I'm sidetracking you, but it directly raises the question of, is the DOE's reconsideration a fix?
It might push out that date marginally, but not substantially. First of all, the example we give in our brief assumed a fuel economy level or fuel economy equivalent for electric vehicles of 160 miles per gallon. That's actually at the very, very low end under the current scheme. So even if DOE amends the petroleum equivalency factor, that's still not going to be far off from the average fuel economy equivalent of electric vehicles, even under that, at that point. The only way that DOE amending the petroleum equivalency factor down would completely get rid of this problem is if it did it to such an extent that electric vehicles had no fuel economy advantage over combustion engine vehicles. And we know that can't be what Congress intended, because Congress created an incentive to produce electric vehicles or to produce dedicated vehicles. And if the Department of Energy reduces the petroleum equivalency factor to that amount, it's completely wiped out the statutory incentive that Congress very clearly required. As long as there's a statutory incentive, this problem arises, where at some point, once manufacturers have created some level of dedicated vehicles in their fleet, and to a relatively small level, the fuel economy standards lack any teeth.
What about the fact that you're taking into account the future years other than 2024 to 2026? So that's forward-looking.
It is forward-looking. So, well, part of the reason that NHTSA did that was because it was necessarily starting with the 2020 fleet. And so it was projecting how that fleet had already evolved and would continue to evolve leading up to model year 2024 when the standards began. And then at the back end, NHTSA was projecting the long-term effects of the rule. So even at that point, NHTSA was not really projecting how, it wasn't this forward-looking inquiry about how manufacturers could adapt their fleets by creating additional dedicated vehicles in the standard-setting years. This court doesn't need to reach that issue, though, because it's clear that any error on that front was harmless. And so the court could just decide that the error was harmless, and it doesn't need to address that. I will note that in NHTSA's recent notice of proposed rulemaking, it has amended the way that it deals with those years to make sure that it is not projecting manufacturers creating electric vehicles in response to the proposed controlled.
On your harmless error argument, I read your brief to be saying that you ran a sensitivity analysis on this asserted error about the extra years, and that it would result in a $1,371 increase instead of a $1,261 increase. And you say this is harmless because in a different part of the regulation, you said that a cost increase of $1,574 would only be slightly beyond the level of economic practicability. Am I reading that correctly?
So what NHTSA said was that regulatory alternative 3 was slightly beyond the level of economic practicability. Regulatory alternative 3 would have caused an additional, in model year 2026, an additional increase in the price of vehicles of $358, the sensitivity analysis that we're talking about would have caused an additional price increase of $155 on average. So yes, the price increase is much less than under regulatory alternative 3, which NHTSA said was just beyond the level of economic practicability.
So there's another error that you concede that you made with respect to the hybrid vehicles. You were supposed to count them only with respect to the combustion engine aspect, but you counted the whole thing. And there is no analysis about the two errors, if we assume this was an error, including the extra years, and the other error. So how do we know that that's harmless, these two errors together?
So correcting the conceded error regarding plug-in hybrid electric vehicles actually would have reduced the incremental price of model year 2026 vehicles by $23. So in some ways, these are likely to be offsetting errors. Now, it's true you can't just add them up and assume that you're going to get to the same result.
You're saying that error goes in the different direction in terms of the...
Yes. Correcting the error regarding plug-in hybrid electric vehicles, if anything, seems to make the standards that
Why
NHTSA
is
shows
that?
more
'Cause
economically.
if you take out the electrical vehicles, wouldn't the price go up?
So they're plug-in hybrid electric vehicles, which are very expensive because they contain both the electric powertrain and the internal combustion engine. Now, consumers want them because they also contain some of the benefits of both, and so consumers are willing to pay more for them. If you consider plug-in hybrid electric vehicles only as running on gasoline, you see less consumer demand for that, and so less purchase of those expensive vehicles. That's likely the reason the sensitivity analysis shows the incremental price of vehicles actually going down.
Can I get back to the text of H for a second? So is it fair to say then, H says the following, and I'm just reading from it. In carrying out subsections C, F, and G of this section, Secretary of Transportation may not consider the fuel economy of dedicated automobiles, and let's just say EVs. What the government says is, actually the way to read that is, in carrying out subsections C, F, and G of this section, Secretary of Transportation may consider the fuel economy of dedicated automobiles as long as, and then you read in a forward-looking criteria.
I don't believe that's right. I don't believe that considering the current state of the fleet is part of subsection C, F, and G. So, it would be introducing an exception that it's kind of not there, right? The entirety of subsection C, F, and G are this forward-looking determination. And so when subsection H prohibits the Secretary from considering the fuel economy of electric vehicles, it's in that context of making that forward-looking determination.
So you would have to say that constructing the model that is going to support the amended standard is not carrying out the function of the provisions that permit the amendment.
The baseline, I'd say, determining where the existing fleet is, determining the current fuel economy that manufacturers have already achieved, that is not part of the mandate in the statute.
As an input to the model that fixes the standard, the amended standard.
That's not part of the mandate of what the statute directs the Secretary to do. What the statute directs the Secretary to do is to make this forward-looking determination of what fuel economy level manufacturers can achieve in the future, considering what technological improvements are feasible and practicable. That's all a forward-looking determination. And it doesn't, the mandate in the statute doesn't go to the Secretary's assessment of where we are at the beginning of the regulatory period.
So if the agency says, you're talking to an agency official and they just say, okay, I'm going to carry out my responsibility, and I'm going to start out by just setting the baseline. And then your view is, well, you're not carrying out your responsibility, actually. You can go ahead and do that, but actually you're not carrying out your responsibility when you set the baseline.
Carrying out the responsibilities is in setting the standards that will have the effect that Congress intends, whatever that is, in a given statute. Constructing the baseline, that is an objective, a necessary predicate first step, but it's not the mandate itself that is in the statute here.
So that would,
Petitioner's reading,
that would just be a mistaken conception on the person's part, is that they're actually not carrying out their responsibility vis-a-vis setting up the standards because, vis-a-vis prescribing the standards because
If
this
all-
is just a predicate.
if all the secretary is doing is establishing a baseline, he's not fulfilling his duty under the statute. He needs to determine what fuel economy level manufacturers can achieve, not what they've already achieved.
But I guess the argument is just that, yeah, if you're just doing the thing that sets the baseline, which is like creating a report, or as was suggested, using that for purposes of an environmental impact statement or something, that's one thing. But when it's the first step of actually prescribing the standard, then you're doing that thing as part of carrying out your responsibility to prescribe the standard.
So as an initial matter, I don't think this court needs to decide whether constructing that baseline is part of the mandate of subsection A, because subsection H, prohibition, is constrained to when the secretary carries out the functions of subsection F, which clearly are forward-looking. But even if this court doesn't want to go that route and does look at whether, what is the mandate of subsection A, it's not subsection A doesn't require an initial step. It's a one-step mandate. Set the fuel economy standard at the maximum feasible level manufacturers can achieve. That's a forward-looking mandate, forward-looking permitting.
Suppose the baseline suppose there were no factual support for baseline in this model. Could a petitioner challenging the agency action of amending the rule say that the amendment was arbitrary and capricious because the baseline in the model that supports the amendment is unsupported?
If there was no, I'm not sure I'm understanding the question. If there was no factual basis for...
Someone is challenging an amendment, and they say the amendment is arbitrary and capricious because it was arrived at through a model whose baseline was X, and there's no support for that baseline.
I think that would be arbitrary and capricious because there would be, without...
Right, in
But
judging the
well,
amendment.
I'm not sure that not because the baseline is arbitrary and capricious, but because the forward-looking determination of the maximum feasible fuel economy level that manufacturers can achieve then has no reasoned basis.
Right, which that makes it sound like then the baseline is an integral part of arriving at that ultimate thing that is arbitrary and capricious.
It certainly is an integral part of the Secretary's decision-making, but again, it's not the mandate that the statute is directed to, and it's certainly not the consideration. It's the subject of subsection F, right? That is the forward-looking determination. Before we conclude, I would like to mention, in case this court determines that there is prejudicial error, whether it's with regard to considering electric vehicles outside of the standard-setting years or considering electric vehicles that already existed, the proper remedy here is remand without vacatur. There's a serious possibility and indeed a likelihood that NHTSA could support and would support the 2022 standards on remand, even under a corrected analysis. And vacatur of the rule would have significant disruptive consequences. It would have serious adverse effects on energy conservation, including increasing gasoline consumption. It would harm the environment and the public health. And it would reinstate the 2020 rule and, in fact, employed many of the same methodologies that petitioners challenge here. So it really makes no sense to reinstate a rule that rests on some of those, if this court finds that including electric vehicles, considering electric vehicles that already exist, if this court finds that that was error, it makes no sense to reinstate those prior rules. At the same time, remanding without vacatur would cause no injury. If NHTSA does determine on remand that somewhat less stringent standards are supported, the statute allows NHTSA to amend fuel economy standards downward at any time, and manufacturers will simply receive compliance credits to the extent that they have already exceeded the standards. In contrast, if this court vacates, NHTSA will have no opportunity to repromulgate more stringent standards, even if the agency determines that's appropriate because of this 18-month lead time requirement in
Can I,
Could they support these standards if we were to conclude that even considering electric vehicles for purposes of the 2020 baseline is impermissible?
Yes, it is possible for manufacturers to comply with these standards even without producing a single electric vehicle. So if you look at the data underlying this rule, for example, hybrid electric vehicles, and there's not plug-in hybrids, standard hybrid electric vehicles, there's no question NHTSA was allowed to consider those, receive fuel economy compliance values in the 60s, 70s, 80 mile per gallon range. And that's in the 2020 fleet, before the technological improvements that will be made by 2026. NHTSA standards in 2026 require a fuel economy level of around 49 miles per gallon. So with increased reliance on standard hybrid electric vehicles, advanced engine technologies, mass reduction, aerodynamic improvements, it is certainly feasible for manufacturers to achieve the 2022 standards even without creating any electric vehicles. And so it would be possible for NHTSA to support the rule even without considering any electric vehicles.
even though you don't have a Subaru line in the record of this case,
We don't have a Subaru line, but from what I gather from the
I
discussion,
think that conceptually it plays out the same way. So I have one question about the way the amendment process works as compared with the construction of a new standard. So suppose we had some back and forth about whether it's possible to construe H as having its principal role in the amendment context and as having a lesser role in the promulgation of a new standard. So I know you've got some problems with that. Let's just bear with me. Let's just assume that's the scenario that we're operating in. Is it set in stone that when the agency creates a new mile per gallon target for a year as to which there's already been one in place, that that's necessarily an amendment? Or could the agency just say, I'm not just picking at one part of the old rule, I'm just vanquishing the entire rule, even though it deals with the same year, it's a year in the future, let's say 2025, so I'm not amending 2025, I'm actually just doing a new rule as to 2025. And then by doing that, have the capacity to take into account by hypothesis electric vehicles to a greater extent than would be the case were it an amendment.
we haven't raised that argument. I'm not sure whether that's consistent with the statute at this point.
Okay.
If it's important, we'd be happy to address that.
Okay, I just didn't know whether whether you knew of something that's set in stone already that says that any time the agency is affecting a numerical value for a year for which there's already one, that's by definition an amendment.
There's nothing that I know of on either side of that question.
Okay. The court has no further questions.
We ask
Thank you.
the court to deny the petitions. Thank you.
Thank you, Mr. Koppel. We'll hear from intervener on respondent's side. Mr. McCombs.
Thank you, Mr. Chief Judge. May it please the court. I'd like to make 2 points about intervener's arguments. So we've heard from interveners that their claim is logically antecedent to petitioners, but we know that's wrong because the only way we reach their EPCA preemption argument at all is if petitioners lose. If petitioners are correct that there's no way to consider any electric vehicle for any purpose at any time, there's no occasion to investigate whether NHTSA can consider these electric vehicles produced in response to California standards. Second, the only way we would reach EPCA preemption in the first place is if it had any impact on standards at all. But on this record, it doesn't. The only way we would get this backdooring effect that interveners are worried about is if NHTSA's reliance on California standards to model the baseline ended up setting the baseline too high. But no one's made that argument. Certainly no one's made that showing. And all the evidence in the record points the other way, that automakers are historically over-complying year after year, producing more electric vehicles than required by California standards. So if anything, NHTSA's proxy for the baseline is too conservative. You can see that at JA 907. But turning to the petition at hand, we have 2 readings of section 3292H before the court, petitioners and NHTSA's. And petitioners runs into several problems that NHTSA's doesn't face. So first is the specific inclusions and exclusions that Congress wrote in subsection H. Second is the structural precision with which Congress wrote the CAFE statute, specifically the role of the subsection factors. And third is the absurd results that defeat both of Congress's express objectives of incentivizing alternative fuel vehicles and keeping focus on internal combustion fuel economy. Returning to that first problem, and it is a big one, petitioners give no effect to the exclusions that Congress wrote into subsection H. It says constrained in carrying out 3 sections, C, F, and G, and it is not constrained in carrying out the balance of the sections, including the standard setting provisions of A, B, and D. And petitioners give no effect to this. The Supreme Court tells us in the National Association of Manufacturers versus DOD case that when we see an enumerated list like this, we need to give effect to those exclusions. So we need to come up with some theory of the statute that explains why A, B, and D are not in, but C, F, and G are. Petitioners' redundancy theory just doesn't work. One of the big problems with that theory is they admit that
Yes, in the abstract, but does that structural intuition have less force in the context of a statute which seems to have some very strange and inexplicable redundancies?
so.
I mean, if they cross-reference A but not B, what would we make of that?
I mean, so I think I hear your question, Judge Katsas, as did Congress write this statute precisely? And there's every reason to think it did, because it was trying to do something very precise. It was trying to incentivize alternate fueled vehicles, but not too much. It was worried about a wholesale switch over. So it was putting its thumb on the scale, but trying to not press down too hard. And that kind of precise balanced objective is exactly the thing we'd expect to see behind a very precise statute. I think the Chief Judge had a question about what the Alternate Motor Fuels Act looked like, and that's in the green addendum at A22 and 24. You see it basically put 2 clamps on NHTSA's analysis, one for the amendment provisions and one for the 4 maximum feasible factors. Now, at the time that it did that, NHTSA had been doing CAFE rulemakings for 10 years. And in every single one of those rulemakings from the very first in 1977, it had always looked at those 4 maximum feasible factors in terms of a specific set of fuel economy improvements that it was considering, whether that's a new engine, technology, or otherwise. And it would analyze each of those factors against those improvements. So it was logical to understand Congress when it constrained the consideration of those factors as constraining the consideration of those improvements. But under petitioner's theory, none of that matters because everything's sort of wrapped up in the standard setting analysis anyway. I think that bears out in their concession that subsection H doesn't bind subsection D. But that makes no sense because the subsection D is the small manufacturing section. And it includes the words maximum feasible average fuel economy, just like all the other standard setting provisions. So there's no reason why there's sort of theory that F distributes everything through that term everywhere. That doesn't make any sense. It also uses a phrase, the maximum feasible average fuel economy level that manufacturers achieve. And that same phrase appears in subsection A. So it doesn't make sense why we can sort of do this workaround and daisy chain these statutes together to get at the standard set under A, but not under B. And the Supreme Court tells us that's exactly how we're not supposed to read an enumerated list like this. In the NAM case I mentioned, we were looking at a direct review statute under the Clean Water Act. And it had, again, the Court of Appeals gets actions that arise under this, and this section. And the government had a theory that, well, you know, we can kind of get there anyway through this workaround. And the Supreme Court said, no, you have to give effect to those exclusions. You have to come up with a theory of the statute that you don't sort of get there anyway. You have to give meaning. I think the last point I'd turn to is the absurd results that petitioners reading creates. It's on their brief. We also raised one, the domestic minimum standard, where we get a minimum standard that is higher than the maximum standard, which cannot be right. And they argue that we got this wrong somehow, that those two are tethered together and they travel together. But that's wrong. On the plain text of subsection B4, the domestic minimum standard is always set at 92% of the projected average fuel economy the combined fleet. In other words, what is the industry's performance overall, not 92% of the CAFE standard.
But didn't NHTSA do it differently?
Yeah, and so ironically, what they're citing is NHTSA's practice over the statutory text, which is not their primary argument. So NHTSA is using the CAFE standard as a proxy for what that industry performance is. And that's very reasonable under their view of the statute, because those two are not going to diverge significantly. CAFE standard is always going to keep track with industry performance because they are using a realistic baseline. It's only when we get to petitioner's partial view of reality that those two start to diverge. If that were what NHTSA had to do, then you would have to get a different proxy to do that projection in before, and we would get exactly the absurd result we explained in our. There are no further questions from the court. Happy to sit down.
Thank you, counsel.
Thank you.
MacArthur will give you 5 minutes for a rebuttal.
So I have yet to hear a textually coherent explanation of how the various limitations the government reads into subsection H can be found in that provision. I don't have any problem with the fact that the statute is forward-looking. The EVs in the baseline don't remain somewhere in the past. They get carried forward into the fleet that NHTSA models to determine whether its standards are feasible and practicable in those future model years. NHTSA's determination is based in part on the presence of those EVs in the fleet, and that transforms them into a regulatory mandate and away from the compliance flexibility that Congress intended them to be. Because they have such a problem with plain text, they go to absurd results. We are nowhere close to the territory of invoking the absurd results canon. They say their analysis would be divorced from reality because the baseline fleet would be a quote-unquote fictional fleet. But the fleet of conventional vehicles is not fictional. It is quite real, and it is only that fleet that Congress permitted the agency to consider in setting these standards. Congress all the time directs agencies to exclude aspects of quote-unquote reality from their analysis, and it had a good reason for doing so here, because it wanted to preserve the incentive it enacted and prevent the agency from turning it into a regulatory mandate in precisely the way the agency has done here. At the end of the day, all they really mean by the analysis being divorced from reality is that the standards will be less stringent than they would be if they were set based on what would be achievable with electric vehicles in the fleet. That is the choice Congress made when it prohibited them from considering the fuel economy of electric vehicles. The other absurd results, subsection B4, the domestic minimum standard, there's a reason you're hearing that only from the interveners and not from NHTSA, because it is contrary to NHTSA's own interpretation of the statute. Council mentioned the plain language of the statute. NHTSA's interpretation is perfectly consistent with the plain language. The key language is that NHTSA must take 92% of the average fuel economy for the combined fleets. Projected fuel economy for the combined fleets. It doesn't say the projected fuel economy to be achieved by the combined fleets. It says for the combined fleets. And NHTSA has reasonably read that to mean projected to be required for the combined fleets. You might ask, why are we talking about a projection if we're talking about the standard? Here you need to remember that the CAFE standard isn't actually a miles per gallon standard. It is a mathematical function that depends on what happens in the future. You only get a miles per gallon standard at the end of the model year. And so when NHTSA is setting the standards, it has to project what the standard will be, and it's that projection that NHTSA uses to derive the 92% for the domestic minimum. And so it completely avoids the anomaly that the interveners have raised here.
Can you just address the government submission that the statute refers, the relevant provision H, the most relevant provision H refers to C, F, and G, but the only reason C and G are included is to deal with the kind of ex-ante intent.
To deal with the
ex-ante intent of whether, as I understood it, that's what they're saying, is that F really is doing all the work here, and C and G are only about the reasons for which an amendment is being undertaken.
I agree with that interpretation. I think F is doing the work when you're setting the standards. And C or G,
even in the amendment context.
Even in the amendment context. And that's because if you look at the amendment provisions, the substantive standard for the amendment provisions is maximum feasible fuel economy. F tells you how to determine the maximum feasible fuel.
So that's the only reason C and G are in there.
As far as I can tell, that's how to make sense of the way Congress approached this. Counsel for Interveners mentioned that I conceded that subsection H doesn't constrain D at all. That is not what I said. D also includes that maximum feasible standard when you actually set the alternative standard for the small manufacturer. That's going to be subject to H because it will be carrying out subsection F in deciding maximum feasible fuel economy. Counsel also mentioned that when Congress originally enacted this provision in 1988, there was an unbroken string of NHTSA having improved the fuel economy standards. That is factually incorrect. As I mentioned in my outset, 1986, NHTSA decreased the fuel economy standards. And Congress enacted subsection H right on the heels of that in 1988. There were some points on harmless error that I would indulge the court's patience to address.
Can you first speak to, before you go to harmless error, and if you could just briefly kind of go through that, that'd be appreciated, but on vacator versus, if we get to that stage, remand without vacator versus vacator, because that's something that the government has argued in both in its brief and today.
Yeah, I actually think it might be more useful if I go quickly through harmless error first and then address.
As a setup?
As
Okay.
a setup to
Okay.
understand the point on vacator. So very quickly on harmless error. We easily carried the not onerous burden that we have to show prejudice. We identified comments in the record that were submitted to the agency explaining that these standards could not be achieved by a fleet of conventional vehicles and would in effect require production of electric vehicles. The agency never disagreed with that, never provided any analysis to the contrary in the rule. What it said instead is that the standards are feasible without further production of electric vehicles beyond what is already expected in the baseline. And if you look at the Auto Innovators amicus brief, they show, and NHTSA doesn't dispute it, that if you back out all the electric vehicles and you treat the plug-in hybrids as gas vehicles as required by the statute, the average fuel economy of the compliance fleet declines by 3.4 miles per gallon. That is a huge difference, and there's no basis in this record to conclude that it would be technologically feasible and economically practical to make that difference back up with improvements to the fuel economy of the conventional fleet. And indeed, even considering all of the unlawful compliance flexibilities that NHTSA considered in this rulemaking, they themselves projected that automakers would fall short of the standard by 0.7 miles per gallon in 2026. Quickly on the sensitivity analysis. There are a lot of numbers flying back and forth between our brief and the government's brief. The good news is, if you agree with our reading of the statute, there is no reason to delve into any of that because they never ran a sensitivity analysis that corrected all of the errors. For these purposes, you can put our errors into 4 categories. There's the EVs in the 2020 fleet, the state-mandated EVs, plug-in hybrids, and the improper consideration of all of the compliance flexibilities in years outside the standard-setting years. As to the first, they never ran an analysis, never said in the rule, do not even say in their brief in this court that backing out the 2020 EVs was harmless. That by itself should be game over for them on harmless error. As to the other 3 errors, they did run sensitivity analyses that corrected them, but only one at a time. They never ran an analysis that corrected even more than one of them, let alone all of them simultaneously.
But as to the first one, they did say remand without vacator.
As to the first one, they did say remand without vacator. They never said that it was harmless.
Right.
The first time I've heard that was from the podium today, and it is a post hoc rationale that should not be considered, both because they didn't say it in the rule and it's Chenery barred, and they didn't put it in their brief and it's waived. Quickly then on remand without vacator, that's the default rule for unlawful agency action, and there is no reason for departing from it here. Both
Default rule is
Vacator.
I said that wrong, I apologize. Default rule is vacator, and there's no reason from departing from that here. Both of the allied signal factors point squarely toward vacator. Here, the errors were very serious, not a case in which the agency simply failed to adequately explain its rationale or to consider an aspect of the problem. They flagrantly and systematically violated express restrictions on their authority, and there's no likelihood, for the reasons I just explained, that they could impose this same rule that has a 3.4 miles per gallon boost from improper compliance flexibilities on remand. Second factor, disruptiveness, as just Judge Katsas explained in his opinion for the court in the Long Island Power case, disruption only matters insofar as it's likely the agency will be able to rehabilitate its rule on remand. For the reasons I just explained, there's really no possibility of that here. And in any event, the egg hasn't been scrambled. If you vacate these rules, it's not as if we're going to be in a situation where we go to no fuel economy standards for the model years at issue. It will, as the agency recognizes, automatically resurrect the prior standards from 2020. There will be no disruption to the regulated industry. The auto innovators are here alongside us in this case, requesting vacatur.
Okay.
No further questions.
Thank you, counsel. Thank you to all counsel in this case. We'll now proceed to the NRDC challenge.
What do you want to do?
Mr. Huffman, please proceed when you're ready.
Afternoon, Your Honors. May it please the Court. The Energy Policy and Conservation Act requires NHTSA to set fuel economy standards at the maximum level that is feasible for automakers. The agency failed to do so here.
I'm sorry to interrupt you. Can you make sure, maybe lower the podium a little bit and make sure you're speaking into the mics? Thank you.
Is that better, Your Honor?
Just project as well as you can. We'd appreciate it. Thank you.
That's right. The agency failed to set required maximum feasible standards because it made sweeping and counterfactual assumptions that excluded from consideration a cost-effective and well-established efficiency technology. First, the agency assumed that no pickup truck whatsoever could use what's called a high compression ratio or Atkinson-enabled engine. Second, the agency assumed that any sport utility or other vehicle that currently uses the same engine design as a pickup truck can't use these engines either. And these assumptions are a big deal. They affect the bottom line. Unlike in the petitions the court just heard, there's no argument from the agency here that the errors we allege are harmless. And that makes sense. The assumptions apply to millions of pickup trucks and sport utility vehicles sold every year. And this is very cost-effective technology. Addressing these vehicles are some of the best-selling and least efficient vehicles out there. Applying this sort of well-developed, the National Academy's reports talk about this technology, applying this to sort of this large portion, an inefficient portion of the fleet is really the sort of core place that NHTSA should be focusing its efforts. And these engines are almost tailor-made for how pickup trucks are actually used in the real world. It can operate in sort of two different modes. It operates in an efficient Atkinson cycle mode for sort of routine driving, which the record tells us is mostly what these vehicles are doing. But it can automatically switch into a higher power called auto cycle mode for infrequent tasks like towing or hauling. The agency says no, categorically, no pickup truck can use these engines. Now, the reason it assumes that, it depends where you look. So it's joint appendix, it's not page 952. This is the affirmative rationale that they gave. This is what's in the Federal Register. And there's not much there. It's a couple of sentences. But what it says is, if you try to use it in a pickup trucks are spending so much of their time doing high load operations that the engine's not going to spend much time in the efficient Atkinson mode, and so you're going to get minimal benefit from the technology. And again, this is at JA 952 in the footnote. They say, and these are their words, they say this is based on confidential conversation with automakers. Now, their rationale is arbitrary and capricious, as we explained in our opening brief, but the agency has also walked away from it here in litigation. This is their response brief, page 113, it's note 25. Now they say they did not rely on confidential data. They say they relied on public data, but they don't cite any public data. Not in the footnote, not in the Federal Register, not in their brief. And that alone makes NHTSA's assumption about pickup trucks arbitrary and capricious. In this court's decision in the Tripoli rocketry case, that's 437 F. 3rd 75, this court made clear that even in areas where an agency claims technical expertise, under the Administrative Procedure Act, the court cannot simply accept technical assumption proffered by the agency merely because it reflects the agency's judgment. Just like in Tripoli rocketry, the agency hasn't provided any data that supports the exclusion of this technology. And that absence of data is also what distinguishes the agency's cited deference cases. Now, in its brief in litigation, the agency proffers a new rationale for excluding these engines from pickup trucks. Now it's not about minimizing the benefit. Now they say if you tried to use one of these in a pickup truck, it would start to knock and eventually break down. So it went from minimal efficiency benefits to it will break. Now, there's no data supporting that either, so the agency tries to sort of reason it out from generalities about basic engine operation. It claims that knock, this is when the piston compresses the fuel-air mixture, and it ignites because it's getting hot before the spark plug goes. And if you hit that, you can make this sort of knocking or tapping sound. It says that that knock is just an inescapable consequence of the physical construction of one of these high compression ratio engines. But we know from the record that that's not true. It's a categorical matter. There are already engines using this exact same physical design in large SUVs that has the compression ratio that the agency says is necessary. And there's hundreds of thousands of these on the road without any knocking problem. Now, even if there wasn't that counterexample in the record, the agency's exclusion of pickup trucks is still arbitrary and capricious because it hasn't offered a sufficient explanation under this court's precedent. So their brief has a lot of words about pistons and valves, but none of that's in dispute. And it all just leads up to a very true statement that if you overcompress the mixture in a cylinder and get knocked, yes, I mean, that's just what it means to overcompress. If you haven't knocked, if you're not knocking, you haven't overcompressed. So it's not explaining anything. What the agency's obligated to explain is why these engines supposedly will knock in every pickup truck. And for that, all they say is that higher compression ratio engines compress more than lower compression ratio engines. That a 13-to-1 ratio is higher than a 10-to-1 ratio. And again, that's true. We can't dispute 13 is greater than 10. But that doesn't explain anything. And the easiest way to show that, I think, is that you can swap in any two ratios you want into their explanation, and nothing changes because none of the reasoning is tied to a specific ratio. So for instance, you could take out the magic number 13, which they say is necessary, and you put in 11.8. 11.8 is the current ratio used by the Tacoma pickup truck. So we know that that works, but all of their reasoning still holds. 11.8 is higher than 10. 11.8 will compress more than 10. And there's also, to sort of correct, it was a little bit sort of misleading suggestion in the brief, there's not an inherent trade-off between increasing compression ratio and increasing power. And the easiest way to see this is at JA 273. This lays out for the Tacoma pickup truck. It's got side by side. It shows it's offered with two different engines. And the lower compression ratio engine is also the lower powered engine.
Do you think they're entirely unrelated?
No, Your Honor, it's just that much more goes into engine design. The brief also seems to suggest sometimes that this is the only variable that changes. Automakers each year just decide what compression ratio and everything stays the same. But you can change the size of the cylinders, the number of cylinders, the orientation of the cylinders, number of valves. There's a whole host of things. And that's what automakers do. You know, they have the design and account for all of these factors when they're trying to put in an engine there. So there's no reason to think that they can't design, use a higher compression ratio and still get more power out of it. And you can see that in the example of the Toyota that's at JA 273. I'd like to shift gears just briefly because there's another independent, arbitrary, and capricious assumption that the agency made that also warrants remand back to the agency. So automakers sometimes use the same engine in different vehicle lines as a cost-spreading measure. So the agency here says that anytime a sport utility or other vehicle is currently using the same engine design as a pickup truck, they exclude consideration that those SUVs could be upgraded with a high compression ratio engine. But the agency doesn't dispute that these SUVs and other vehicles are technologically capable. They just say that it's too expensive for automakers to break up an engine sharing family. But we know that that's not true also because of the record. The only example the agency gives of an engine sharing family is the family that includes the Chevy Colorado pickup truck. And the cites are in our reply at 22. But in the prior round of rulemaking, that family included the Chevy Equinox SUV. Now, under the agency's reasoning, Chevy would have had to have kept the Equinox on the same engine path as the Colorado pickup, but that's not what happened. The automaker broke up the engine sharing family. They upgraded the Equinox with a different engine. So it shows that it can be economically practicable to break up these engine sharing families. And even ignoring that sort of contrary record evidence, the agency's economic rationale is arbitrary because it fails to account for the statutory factor, which tells the agency to look at what's economically practicable. So even if it were true that it would be more economic to generally keep engine sharing families together, it doesn't mean that it's impractical to break them up at times, particularly when the agency does not dispute that these other vehicles are technologically capable of using this particular engine technology.
So with respect to the disparate treatment between SUVs and pickups, is that something that was preserved before the agency? If you can just tell me, like, how was that raised before the agency in the rulemaking? Because it looks like, from what I can tell, you were relying on a comment that seems to me a little oblique. Pickups have 18% to 19% higher power to weight than both cars and truck SUVs. Was there something else? Because it's just not clear that this particular argument about the disparate treatment between SUVs and pickups was put before the agency.
Yeah, sure. When the agency made these proposals, they laid out certain criteria that they said, render these engines ineffective. And we and many other commenters put in comments that said that none of those rationales are valid. Like that these technologies, high compression ratio engines, should be able to apply to every vehicle in the fleet. So we would definitely, the agency was certainly on notice that public commenters thought that these engines could be used on all of these vehicles, if I'm understanding Your Honor's question.
Yes, but nothing more specific than that with respect. I mean, you just make very detailed arguments here about specific SUVs and models and things, and it wasn't clear to me the agency had a chance to respond to these types of very specific arguments that you're making.
Yes, Your Honor. The comments were very detailed. I don't think they're maybe not quoted in the agency's response to comments, but some of these comments they're dozens of pages long, talking about how these engines can be used in these vehicles, and from like expert regulator like the California's Air Resources Board put in a comment with a lot of detail on it. It's actually useful to point out that NHTSA is the only agency that seems to think there's a problem with this technology. Both the regulators at California's Air Resources Board, the EPA also in their last rulemaking acknowledged that at least 6-cylinder trucks, all of them could use this technology. So NHTSA is really off on its own, and they have no data, and it's arbitrary. Are there no further questions?
Okay, we'll give you some time for rebuttal. Thank you, Mr. Huffman. Mr. Koppel.
May it please the court. In setting fuel economy standards, NHTSA uses the CAFE model to simulate how the entire car fleet will evolve years into the future in response to proposed fuel economy. And NHTSA accounts for more than 70 potential technological upgrades that manufacturers can use to improve the fuel economy of their vehicles. NHTSA necessarily makes determinations about how certain technologies are likely to be used and which applications of those technologies are a feasible means to improve fuel economy. NRDC's petition focuses on one of dozens of technologies, a high compression ratio engine. And NHTSA reasonably determined that that particular technology is not a feasible means of improving the fuel economy of pickups. NHTSA explained that as between two otherwise equal engines, a high compression ratio engine will produce less power and less torque than a standard engine. And automakers want to maintain the power and torque of their pickups in possible contrast with their passenger vehicles and SUVs, because that power is critical to the pickup's ability to haul and tow, which is a key feature of the pickup truck. Perhaps most tellingly, the reasonableness of NHTSA's determination is confirmed by automaker actions in practice. Faced with increasing fuel economy levels, both before the 2022 rulemaking and after, we would expect that if high compression ratio engines were a feasible means to improve the fuel economy of pickups, we would expect automakers to be using them. But the record shows that the opposite is true. In the model year 2020 fleet, there wasn't a single pickup that used a high compression ratio engine. And recently, actually, Toyota announced the 2024 Tacoma, which is a vehicle that previously used what NRDC erroneously labels a high compression ratio engine. Toyota announced that the Tacoma is going to have a turbocharged engine. Turbocharging is a distinct technology line that can be used to improve the fuel economy of pickups. So that vindicates NHTSA's decision to model Toyota taking the Tacoma down that turbocharging path as opposed to the high compression ratio path. The prediction that NRDC says was arbitrary and capricious turns out to have been exactly correct. To be clear, NHTSA didn't say that a high compression ratio engine can never work in a pickup. It said that it's not a feasible means to improve the fuel economy of a pickup. So take a hypothetical pickup with a 3.5-liter, 6-cylinder standard engine. An automaker may be able to make that pickup work with all the hauling and towing capacity by upsizing the engine to a 5-liter, 8-cylinder engine. But that's not going to improve fuel economy because the larger engine, even though it's a high compression ratio engine, will burn more fuel. And there will be more energy losses, pumping losses, and friction losses because it's a larger engine. And the automaker may have to redesign the truck to fit the larger engine in the truck. So that's going to be a very expensive proposition. Again, it's just not a feasible means for an automaker to improve the fuel economy of a pickup. And again, that's borne out in the record.
What's your response to the other side's argument about the comparable SUVs?
Yeah, so they cite the Palisade and the Telluride, which had high compression ratio engines and maximum torque levels on par with some pickups. But those are not comparable engines. First, the Palisade and the Telluride have 3.8-liter engines. The pickups they compare it to have 3.5-liter engines. So the SUVs have engines that are 8 to 9% larger. And as a result, if you actually look at the fuel economy of the Palisade and the Telluride, they're around the middle of their class, medium-sized performance SUVs. They're not getting huge fuel economy benefits. Furthermore, the maximum torque numbers that NRDC cites are misleading. Maximum torque is produced at high engine speeds, say 5,000 revolutions per minute, but pickups need to be able to produce power at low engine speeds, 1,000 RPM, because that's going to reduce the wear and tear, that's going to reduce the risk of damage. And so comparing max torque doesn't demonstrate that these engines are actually...
Well, and why is that? So it sounds like what you're saying is it's just, by definition, SUVs and pickups are not comparable.
No, what I'm saying is that, pickups are designed to be able to produce lots of power at low engine speeds because they need that to tow. When they're towing, they might be towing for hours, and they can't be operating at high engine speeds the entire time. SUVs aren't designed to tow. And actually, if you look, for example, at the Palisade and the Telluride, their towing capacity is lower than the Tacoma, which NRDC compares them to. Furthermore, if you look at the owner's manual of the Palisade and the Telluride, the driver is warned when towing uphill, make sure to keep your speed at 45 miles per hour or less. You're not going to see that warning in a pickup because pickups are built for towing, they're built for hauling, and they really do have more capacity. So again,
Are you saying that the examples they give of SUVs that, like the Palisade and the Telluride, they do not share parts with pickup trucks?
Those don't share parts. So they cite the Palisade and the Telluride use high compression ratio engines,
Yes.
but they're not producing First of all, if you were to keep the size the same, they are not producing the same power or torque, which pickups need. They don't really have the same power and torque and towing and hauling capability as the pickups. So that, the notion that, look, we have some SUVs that have high compression ratio pickups, that does not demonstrate that high compression ratio engines are a feasible means to improve the fuel economy of pickups without compromising on power, torque, hauling, and towing.
Yes, but I thought part of their argument was, even if you can establish this doesn't work for pickup trucks, based on this assumption of part sharing, you imputed in your model that SUVs shouldn't have Atkinson engines either, but they can.
So that's a separate issue, I think, distinct from the Palisade and Telluride issue. I'm
Yes.
happy to address that. So NHTSA did not assume that no SUV could use a high compression ratio engine. But manufacturers use part sharing to achieve economies of scale, share research and development costs, and it's an important part of their business model. And so NHTSA determined that when manufacturers share a part between multiple vehicles, if that part in one vehicle is going to receive some kind of technological upgrade, NHTSA is going to model that in the other vehicles that share the same part, because that keeps this part sharing, it continues to model part sharing. And so necessarily, NHTSA said that because pickups cannot use high compression ratio engines, we're not going to model the application of high compression ratio engines in vehicles that share an engine with pickups. Now, it's true that sometimes automakers break up part sharing families, but first of all, that really is, I think, on the margins. The model necessarily has to make tractable an incredibly complex reality. And so it is a valid assumption that manufacturers will continue to share parts. And NHTSA has no data on which part sharing families a manufacturer might break up. And so it really wouldn't have a reasonable basis to model particular families being broken up. I think that it's also helpful to think about this through a particular example. So take, for example, the Toyota Camry. In the model year 2020 fleet, there were 23 variants or trims of the Camry, the XC, LE, XSE, et cetera. Most of those 23 variants used a high compression ratio engine, but 3 of them did not. Toyota wanted to provide its consumers with an option to have a Camry with a more powerful engine. So for 3 of those trims, they used the engine from the Toyota Tacoma pickup, which does not have a high compression ratio engine. So, and for those 3 models only then, NHTSA did not simulate the application of a high compression ratio engine. So yes, it's true that Toyota could put a high compression ratio engine in the Camry, and for most of the variants, it did. But it wanted to provide this other option. And the only way that it can do so economically is not to create a whole new engine, more powerful engine for these 3 trims, but to share parts. And that's what NHTSA was modeling when it modeled part sharing. Not only does that address the SUVs and passenger vehicles that share an engine with the pickup trucks, but it also asserts the miscellaneous other alleged errors that the NRDC asserts. So part sharing explains, for example, why NHTSA didn't model the application of high compression ratio engines in vehicles that share an engine with a vehicle with 405 or more horsepower, and it didn't model the application of a high compression ratio engine in those GM vehicles that used a variant of the same engine as the General Motors pickup trucks. Unless the court has further questions, we ask the court to deny NRDC's petition for review.
Thank you, Mr. Koppel. Mr. Huffman will give you the 3 minutes for rebuttal. Ask for.
Thank you, Your Honor. Excuse me. Thank you, Your Honor. So I just want to point out that counsel got up and talked about now supposedly it's low-end torque is a differentiating factor. You mentioned towing uphill. Again, none of that's in the rule. None of that's even in their brief. This is all new stuff. And he hasn't, the agency hasn't shown that they even have access to this data that's now supposedly the determining factor. Another thing is that they started off sort of describing the burden of the task or something like that, how they modeled 70 technologies and how there's got to be some allowance. And we don't sort of dispute that as a general principle, but we're not asking them to model some prototype widget that's going to go on like a niche portion of the market, three-wheeled motorcycle. Right? We're talking about the biggest block of the least efficient vehicles on the road, millions of vehicles sold every year. We're talking about a technology that's very well developed, very mature, and as they acknowledge in their brief, essentially all you need to prime it or to get it going is the ability to vary the timing on the valves. And they acknowledge that essentially every vehicle sold today already has that. So the fleet is primed to sort of expand this technology. And I also want to point out that in their modeling, they have an incredible ability to fine-tune the model. We talked about how like pickups need to tow, and they might be doing it, all day long up a mountain or something like that. The record data is that overwhelmingly pickup trucks do not tow or haul. 75% of pickup trucks tow one time a year or less being zero. NHTSA doesn't have to make it an all or nothing proposition. If they really think that there's some, portion of the fleet, behemoth trucks that are towing all the time, they can allow the model to exclude it on those and allow it to propagate to the other 75, 80% of the fleet that could use the technology. So these are not real constraints that the agency has, if that's its real concern. Are there no further questions?
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.